Any municipality officer would have part of this.
Yeah.
Thank you for
Well,
checked in
chair.
with me yesterday
Yeah.
morning because
Chair, school board
Yeah,
chair.
no, I was like reading, they're like, what are they
I
saying?
get
Manager.
those notices from the folks from records and management.
President of the Overlook
Yeah.
Cemetery Association.
Don't get me going, don't.
Yeah, I hadn't caught it, like I
They're
said,
getting
that
a lot
they
of money and stuff, right?
had the
Yeah.
boards, specific boards that were gonna pull out.
Yeah.
Something more to do.
I haven't too much of it.
Anything else on the,
That's interesting.
Nope, this was
Okay.
the open meeting last
Great.
time.
Thanks a lot.
thank you. Lori,
Thank you for finding it.
For, I guess I haven't formally been introduced, Lori Fisher. You did invite me one day, I wasn't able to catch up. But anyway, I'm Lori Fisher from the Attorney General's office, and I'm assigned currently to be general counsel to the parole board. So I show up from time to time and available for questions if any come up in the meantime.
gives us good advice.
Yeah, I don't know.
You mentioned the Human Services Board. Are you that for that board as well?
I am the director of the teams that go in front of the Human Services Board. So
Oh,
I
'cause I'm
also,
on that one as well.
I thought you were,
Mhm.
you were. Yeah, I represent, I'm the director of the Economic Services team and the DEVA team that does the Medicaid work. And so, yeah, for purposes of this, I also director the DOC team. So the interesting wrinkle in this position is we've got some money put aside to get you all separate counsel. That's not me, because the other part of my team actually prosecutes in front of your board. And so we have to keep a wall up between what they do and what I do. But I also do work for DOC. I do their litigation cases in court. So when I first took this position, I immediately was like, this is weird. But no one has an answer other than that's the way it's been done. You need to do it. But we were able to work together and get some funds secured, but no private attorney, outside counsel has bid on the RFP yet. So we've got to, I would feel better for you guys that you didn't have any overlap in these divisions from the AGL.
And I gotta keep pushing for more funds because we were allocated 25,000. And
Oh,
Not very much.
nobody wanted to bite
Yeah.
at that. So I
Yeah.
gotta continue to keep advocating.
Would the person
more
be
funds.
an assistant attorney general if they took on this contract?
No, they'd be
Private
private
counsel.
outside. Yeah. I went to the general and asked about getting someone from another division who has experience in the criminal matters to potentially, so that our team was separate from that. And I'm being told there's no position available, no attorney available to do that. So I did try to go that route as well. It's really been trying to make the pitch to the private bar any chance I get, especially the younger attorneys that have a lot of fire in them to learn stuff, to jump on board too. But until then, you're stuck with me. So I shall do my best.
Would they have the backing of the attorney general in terms of lawsuits and things like that?
They would, yeah, they would. And I think if it came down to on the appellate work, they get specially assigned, so that they can do that. But any attorney that's hired, just for an FYI, any attorney that's hired that's not AGO for state government has to be approved by the AGO. So a lot of people don't understand that kind of layer, because statutes say the AGO is the lawyer firm for the entire state. So we rarely run into anything that would cause me concern as far as advice versus prosecuting cases in front of you, which kind of segues into what MJ's got me on here for today on the collaboration. I just wanted to brainstorm real quickly with y'all, or have you at least think about it until I see you again, about is there any opportunities I can present to the board from the DOC side by way of education, a speaker at your meetings on a particular topic, something more broad and general with DOC, something from like the criminal division of the Attorney General's office, if that's helpful. Is there anything I can do to kind of help uniformity? The context of this is that I did some trainings for a group of parole officers recently, and they started asking questions about the parole board, and it led me to believe that they maybe don't have some of the foundational stuff about you all. And in turn, I think maybe sometimes there are things about DOC that either you haven't had contact with in a while or otherwise don't understand why they're doing something the way they are, so that it helps you work. And I say collaboratively because even though you guys are separate entities, they're the police, the law enforcement for your rules and your what you put down for conditions. They're the ones that have to enforce them. They should have a clear understanding of what you guys are looking for when they come before you. And I don't know that they do. So I was just talking to MJ about how we can collectively kind of work on this, or if there's stuff I can bring to you all that you're interested in to help with that, I'm happy to do so.
Well, I know one I ask about a lot is, do they have a recent record check? And that varies greatly depending on where we are in the state. And especially if they're out on community supervision furlough, it should be 30 days or newer. And we had one not too long ago and it was last done in like 2021. That's not good enough. Like, we need to know if we're going to put this person on parole, have they been towing the line while they've been out on furlough? I think that's important that they had done a record check.
Okay. And I don't think their policy, their protocol requires for that, but we can certainly talk about that. Record checks.
Something that I put out multiple times. I haven't put out in a while. So I used to do periodically little updates or newsletters like quarterly, just to.
Typically what we do, or if someone comes in and they don't have a current one, we'll make a decision that's contingent on a review of a current one. And just let them run the check and then get back to the office with any concerns.
So what is on the check that is not on the parole, any summaries or any intel that you guys get?
Included in the summary too, a lot of the information from the record check.
Okay.
I think the big thing is like with another big one is with like, sometimes the summaries are written in the facility. It's been 30, 60 days because the person's been bounced around. They're now out in the community. It's also another just double check to make sure for even the PO to make sure that they're behaving the way they should. They haven't picked up any new charges.
So there.
We know when they pick up new charges, but
have been a few hearings where, and it's very rare, where they run the record check and they discover that they picked up something that they didn't
There's
know.
warrants that they didn't know about.
But
There was
back,
that one guy
back when we used to have a physical record check, probably a couple, 3 times a year, I'd find people are wanted in another jurisdiction, which was news to the PO. Now we don't get the document in front of us, but it is what it is, I guess. But and what MJ was talking about, sometimes a guy that's been incarcerated, they run a record check on his admission. And maybe a year and a half later, he's been bounced here, there, and there, and they just use that record check to present to us.
Gotcha.
And this guy's been out and in and out, and maybe you picked up charges in a whole nother jurisdiction. So,
all right, I'll inquire about that.
What's interesting though is that I'm happy to see too that a lot of POs now are learning how to read the record check. Because when we used to get that,
They didn't know how to
so
read
now
it.
they do. It's great to see them reading through, giving us a summary of offenses, the latest ones.
Okay. All right, good to know.
Yeah.
Anything else that's super obvious to y'all that you don't think you're seeing or getting on the frequent? I know one thing that I have to defend a lot, and I go at DOC a lot about, is updating things like the risk scoring.
Yeah.
You know, there's triggers to those when those happen, and they're not always getting done at the time that those triggers happen. So we're working on that piece as well to make sure that we're following policy on when those are being done.
So maybe some education, because I know I'm not familiar. I don't know if any of the board is familiar, members are familiar with when those are updated. I haven't looked at the policy for years, but I know there's been a lot of
Risk
change.
assessments.
Yeah, and how recent they're supposed to be done, when the triggers, because there's a trigger between the prison intake to the community supervision tool and those
Yeah.
things. So maybe
Well,
some education around.
Prisoners' rights, certainly. Prisoners' rights is all over those scorings right now. So it's been a heightened area of work recently.
So one of the things that would be helpful to get another update training on, especially with 2 new members, is risk assessments.
Yep, I can make that happen. I just think it'll be easier to have fresh perspective. You know, Gary is doing a lot of work now that he's the sole man currently in charge of field ops. By the way, a quick update is that the state's attorneys so we got rid of like the work camp, the weekend, work camp, people serving their time on the weekends or doing their community service. So they may be reestablishing a short-term sentence style program where they can get pre-approved furlough for up to 45 days to allow them to handle the smaller, lesser charges. So they're working on that too, which I hope, if it comes into play, will change the statistics on who comes back and how often you all see them. So working on that piece too, but risk assessments, okay.
The transition to the new parole summary has been great. And not everyone's using it yet, but I think once they do.
That, I think, so that's a bigger, I can talk to that one. There's a hold off in everybody using it because it's going to go into the offender management system. And that's supposed to be rolling out on July 1. I need to follow up. I think it's going to be a little bit later. We've been doing a lot of work. I've been working with DOC to get a lot of this information automated into it. It's going to look a little bit different. It's coming. I just don't have a firm date. I was going to hit that a little bit in the SDMF conversation, but it's coming. We're just trying to automate to help reduce some of the workload of DOC staff on some of those pieces that is already in the system for them. So you can get better information on the areas that they need to fill in.
Well, and the hope with the automation of these forms, which is a real focus of the commissioner, is to get consistency. So you guys see the same form every time, no matter where it comes from in the state. And then that'll, it's like with the case staffing, when that form was developed and revamped, it's just so that the staffing form is consistent and the language used is consistent every time. So they're trying to develop more and more of these kind of plug and play forms so that you guys get the information that you want.
And all the reports that we request of folks are going to be automated for them. So it's not just the parole summary. The violation report already is. The early discharge, all of them are going to be automated.
The other piece on, I think it helps maybe, and tell me, you can, again, percolate on this and let me know, but I think part of it is letting you know what DOC is developing and struggling with sometimes based on the requirements from the judiciary. As an example, I think some of it will roll over into your work as well at some point. But it prompted me to do research on a topic, which I found, and I don't know why, I've never seen it in any of the other attorney stuff before. But there's a case the Supreme Court has said that rules of criminal procedure and evidence are relaxed in violation of probation hearings. And there's some nuance in there that could apply to parole as well. Because obviously all the criminal adjudication has been done by the time they're at your level. And so with that being said, it's created, some baseline law for us to kind of push back when there's an attack on, or an attempt to make your process be as though it's a criminal trial. So I've been developing that in support of, potential appeals that could come out of what you guys are doing. And then, am I
Have
okay
a
to,
case off the top of your head?
what's that?
The case that you're referring to? off the top of your
I
head?
do, I think. Tone, is it on?
Have trouble with one phone.
I know. Well, and then they give me, I mean, like, I am obviously not a small human being, and they give me the tiniest little.
Big.
It's just, oh, my new attorneys, the young ones that come in have these big beastie ones, and I'm like, what? Thought I had it right here. Wait. I'll send it over to you guys. I just sent it to the commissioner. Yeah, it's State B. I can't remember if it's Benton or something like that. I'll look it up though
Thank you.
and get it over to you. But I found it interesting. I'm like, this seems kind of obvious to protect your process. But one of the pressures that I have to go meet with the commissioner with later on this is that this, and see, we talk about consistency all the time, right? It's my favorite word. The judges are all different when it comes to things like arrest warrants. And the judges are, some judges just a notation into the Odyssey filing system or some sort of notation on the affidavit of violation is sufficient. Others kick back and are now all of a sudden, I don't know why this is just trending. And then judges are now kicking back and saying, no, you need a Rule 4 criminal procedure motion, which is a full motion, which POs, we can't allow them to just file legal pleadings. So, I mean, the potential ramifications of having 2 or 3 more attorneys for DOC just to do warrants every day is real. But what, so we developed kind of a process where we file our affidavit and a letter to the state's attorney who's authorized as the prosecuting attorney in the case to file a Rule 4, request for an arrest warrant. Well, that wasn't sufficient. And so right now we're working with the judiciary to kind of figure out a resolution because each office has to do something different to get an arrest warrant out of the court. And so it's that kind of stuff that just chews up time all the time and process. So what that leads me back to is the OMS putting the forms in and getting everything templated so that we can consistently, and then all the officers know they've dragged down and pulled out what form they need. So
So kind of to hit when you talked about warrant use sparked something in my mind that I bounce up against every day. And I don't think the board necessarily does, but around emergency arrests. I keep hearing throughout the state that there's a different standard to emergency arrest of parolee than a parolee. And I don't understand what the difference would be, but I keep bouncing that up.
They also keep saying that one has a higher level of supervision than the other,
Right.
which is not accurate either. So I don't know that I would regard any of that personally.
Yeah,
as
so
fact.
I'm just curious as we're kind of hit our next topic on parole violations. I want to hit a little bit of that, but I wanted to just, if it's something to flag for future discussions.
Well, and I can memo it for you guys and explain the difference between the two by statute.
Yeah, I know the difference. We know the difference. I just don't know what's going on out there.
Yeah. Well, I think there's, again, a hangover from days gone by where things were a way and they're a certain way. And that's the way we've always done it. And that's just, it's time. It takes time to change that up. So anything that you come up with, you're like, hey, we want to know more about this. You see a pattern, you see something that is happening that you're like, I want to know more about this. Please let me know. And I will get you guys that resource. I'll get someone here to talk to you about it. And then you can ask questions of the source. It's changing every day. It's changing every day. So
I'm kind of shocked that none of you kind of spoke up, because it's one thing that you're kind of curious on that I hear a lot is around furlough violations and the case staffing process. I would love to get education in on how they make the determinations, because I don't know, because a lot of times I'm hearing they're just warehousing the individual or this, that. I just don't know if anybody's really clear on how they're making their decisions. So I would advocate for some education, but
Well,
I
and
don't know.
the piece with that is that my team defends those decisions. So we're constantly in the courts explaining what happened and what's going on and what the foundation of evidence is that supports the decision. The affirmation rate is really high. We're in the low 90% of getting their decisions affirmed. So we're really, got some solid law on that piece, but what they actually do in the process, happy to.
Or are the
Think about
numbers still trending down in terms of folks on furlough that are?
It has been. The last time I did it, now it's probably 60 days out that I had to present. I have to present those numbers to the general all the time, what your caseload is versus the furlough caseload, and it was still more trending in your direction and less on furlough. Yeah. I think that those numbers will change out of the gate if they go to this pre-approved furlough process for the lesser crimes. But yeah, that's the trend I'm still seeing. Yeah,
Assuming this pre-approved furlough is to replace the old work crew,
it is. Yeah, the old worker. Yeah, it
which
just
those numbers were always kind of, nobody ever knew what the actual numbers were, I don't think.
yeah. Well, it's interesting because the prosecutors and defense counsel still wants to pretend there is work crew, but there's not, and so that's why we're trying to collaboratively work through that process. The only other thing I had on my item, and we don't have to talk about specifics about it at this time, I just wanted to alert you, it's probably going to be appealed by prisoners' rights to the Supreme Court. Judge Tomasi has issued a decision lately in a case. It was Justin Redcross's appeal. Justin had appealed. Justin was an individual that came before at least a panel of you who was in a programming situation and got terminated from programming. The dispute was whether or not it was his volition to get terminated or if it was something outside of his control. He's now released into the community, so we're past the hump there. But the judge made us out of nowhere. Prisoners' rights mentioned the Administrative Procedures Act in relation to parole boards decisions. And the short story is that certain administrative decisions go through a different process. Like Human Service Board appeals go directly to the Supreme Court. And there's specific rules on what the printed case is and what happens. There's no intermediate after the board has made their decision. Judge Tomasi believes that the parole board decisions should be treated in the same way. That they don't get an opportunity to appeal to the Superior Court, that they go right to the Supreme Court for appeal. Both the prisoners' rights and my briefing, he made us supplement it once at least. And the briefing was, I found nuances that nothing applied in the APA to you guys. There's only one rule posted under the parole board from the APA, and it looked like a rule that was like in conjunction with other boards. I don't know what the trigger was on that, but it's not like you guys enact rules and are required to under the APA. And I would also argue that the appellate rules that apply to you folks allow the trial court appeal. It doesn't make sense. So ultimately, we won the appeal, and he upheld the decision, but said moving forward, he thinks your appeals should go right to the Supreme Court. So I was told that prisoners' rights is heavily considering appealing it.
So would the decision have to be made then by the Supreme Court?
Yeah, well, my instinct, and based on everything I've seen, is that they're not going to take on. I mean, not that you guys have a zillion of them, but that doesn't make any sense. The legislative intent of the structure of the parole board, your reporting authority, it doesn't make any sense. I mean, you guys advise the governor on pardons. I mean, there's all these other layers in there that it doesn't make sense. Why Judge Tomasi, don't know if I sent you the decision, MJ, but I can send it so MJ can circulate it. But he feels that matters that come from the parole board appeals are considered contested cases, and contested cases go right to the Supreme Court. There's not one decision, there's not one appeal that hasn't gone through the trial court, because everyone's understanding has always been. But he has now bootstrapped it to the APA. So we'll see where that goes. There's really no dog in the fight, in my opinion, for the board. I don't think it matters to you guys how the appeal comes out. But I think it's ludicrous to suggest that appealing to the Supreme Court isn't like filing an appeal in superior court of a decision. It requires extensive briefing, citation, notation, legal argument, court time, when these can be addressed at the trial court level. So if they appeal it, I don't know how aggressive, absent, and we can have conversations in executive session about legal work at that point, but whatever you guys feel how we should approach it. But I don't know that, there's really anything that you guys need to hang your hat on in relation to that. It's just an outlying decision that just came out. We're all like, what happened? So I just want to alert you to that it was based on the Red Cross case, which has been really in appeal way too long, months and months and months. So
the other one I would have is on here. It's number 6. That when we have people in front of us that are on furlough interrupts. I know we talked about it before. It bothers me to parole someone who's on a furlough interrupt, because my judgment is that DOC has made a determination that this person has done something unlawful or not followed the rules of furlough, and they're on an interrupt 1 year, 2 year, whatever it is. And then we are going to sit on our high horses and say, oh, that doesn't matter. We're not going to listen to DOC. We're going to put them on parole. And that bothers me so much that if we're trying to work with them, why are we overriding them? I dislike that.
Are we moving to this, or is this something you want to add for future education? I'm just trying to figure out, because it's.
Well, it says here, working with other departments. If we're
Yeah,
going to work
no,
with
so I
other
just-
departments,
okay.
that one to me is really troublesome.
Yep.
In my
okay, noted. Yep. The one thing too, and I can get you guys decisions as much as you want to read them and before you sleep at night. I can get you the furlough affirmations or the ones that are overturned. I can get you both. You can look at them and see furlough interrupts 2 or 4 years in length are the most difficult, obviously, to uphold, because that individual is not eligible for furlough release for a longer period of time. But the courts look at an abuse of discretion and what the courts considered, what the department considered in imposing the interrupt on the grid. And so we've got some really solid law on that too, and what they put into it and what they're required to put into it. So also on a separate kind of training mode, we can look at some of those decisions, and then maybe it'll give you more of an understanding as to what that means, other than,
So the issue, and we've talked about it quite a bit.
Yeah.
And I have too, and I have with most of the other board members, is that with an interrupt, it can't be the board's decision not to parole them because they're on an interrupt. Solely on that issue. There has to be, if they're entitled to be seen by the board, then we have to evaluate them based on all of the circumstances, not just the fact that they're on an interrupt, which in our past is what we did. If they were on an interrupt, they weren't being considered for parole. Sort of back to that, but now it's a combination of, okay, they're on interrupt. They've got 6 months left. What's the plan going forward? Were there pending cases, which many times there were, that have been resolved? How do we take that into consideration? The simple thing for us to do is just not parole them if they still have any time left. We have to indicate that the reason for it not granting parole is something other than DOC imposed interrupt.
It can be, yep, absolutely, Dean. It can be considered, and I know we talked about this at a previous meeting. It can be considered, it should be considered, by y'all. But as far as it being the sole reason why you deny parole, that's where the appeals have said, no, you have to do your, due diligence and review all of the information and give them a shot, based on all of the entire record, not just the interrupt. The thing with the interrupt that I think that frustrates, and again, I'm kind of projecting a little bit on this, but that frustrates the department if you all decide to override an interrupt on your process. It feels like you've not inquired on the reason why they got there in the first place. No, you haven't looked at the information as to what got the department to that conclusion, and that it's being completely disregarded. So I think best of both worlds is that you consider the information, and if you don't get the information that you are seeking, we've obviously been affirmed a couple times on your ability to ask for more information. So
Most of the time we do get why they're on the interrupt. It's
Good.
written in the parole summary.
Yep,
They
good.
tell us, yes,
good.
yeah.
Yep, good.
So most of the time we do know how they came to that conclusion.
Yep, good. Okay. As long as you guys know and have that information, that's what's most important. What you do with it is obviously your call, but
Means that not be the devil's advocate, like I have a hard time being, following up with Lynn's concern. Because we're on the new mantra of furlough and parole, same thing. Could be no difference. So we have a furloughee out there who's had sanction, and maybe they finally hit the gold star sanction or committed a new crime. Boom, interrupt. Back. We have a parolee that we've seen for drinking and it's not jailable. So we give him a sanction, we give him another sanction. And then finally, we revoke his parole. And if we do, what's the worst we can do to him? As far as the sanction is 30 days, not a 2-year interrupt, but 30 days or revoke his parole. And that, where does he go from there? In and out of furlough, more likely than not. Oh,
He's case staff.
Case that.
He or she's case staff.
yeah.
Now to that interrupt charge.
2-year interrupt.
well, that gets me back to collaboration. I mean, if you think about that for a second. Yeah.
And that kind of goes into some of the parole violations.
Obviously, furlough is stronger than parole when you sign it that way.
And that's
Sure.
And that's kind of where I wanted to go in some of the parole violation discussion too, of some of that, because it's a vicious cycle.
Mhm.
And then in that case, somebody could have had their parole revoked, then they were case staff to a 2-year interrupt, or even a 1-year interrupt. They've resolved their new charges. That's why the board put them back on.
Mhm.
They've got a new minimum. Now they're up for a eligibility hearing.
But
You're
they're on
ready
an
to
interrupt.
parole them again before their interrupt's over. And it's this vicious cycle that and then POC's like, what are they doing? And that's what I hear all the time. And I think that's what Lori hears sometimes is, what is the board doing? I don't know. I don't understand their thought process. So that's some of what I want to talk, at least in the violation part, is I think we need to educate too a little bit more of
Agreed.
how the board is thinking and what your processes are, and how you, like with SDMF, I started doing some education there. They're really looking for some violation stuff and really polling them as well for what kind of education that they need from the board. Because the question is I don't know how they're making their decisions. And I hear that repeatedly throughout the state. It's not just coming from one area. So.
Yeah, I mean, you're not wrong in the analysis of what
Yeah.
authority and what you can do versus what can be done on furlough. Yeah, absolutely.
Well, I guess I would challenge that to some degree, that I think from my perspective anyway, it's very easy to explain why we made the decision we did. I don't find that a challenge at all. And I'm happy to meet with any of these folks who want to know what process we go through. As I said a few minutes ago, I think where we had been was not considering interrupts at all, based on an earlier discussion we had when that was the sole reason we denied parole. And I get that. So now when we look at a new case that comes up with a new minimum, we're looking at a new set of facts. We know their history. We're not considering the interrupt. We are now, but we weren't, as a reason not to.
But when
grant
did we
parole.
make the decision to consider it now? We have not made that official decision as a group, and I was hoping
What do
we
you
could.
mean when you say
Well, you're saying we're now considering, but we weren't.
because they're
considering.
eligible for parole, we have to.
So I'm confused. I'm just confused where you're saying we were. I guess that we are now.
Yeah, me too, because I didn't.
I'm really
and
confused.
I shared that with you, Dean, is
Right.
that I've been doing this a year and a half, and that change has happened while I've been here, and
Right.
I don't know why and when it happened. Is that before it was like, oh, they're on the
It
interrupt,
changed-
oh,
it changed
sorry,
from the
and then
time
now.
We had the discussion about denying parole for interrupt reasons only. That could not be the sole reason we denied parole, which it was. If there was somebody that was on an interrupt, we didn't grant them parole, period.
And I think some of these policies, I would advocate I would advocate some of these decisions be made as a group under a motion. So everybody's clear whether or not we're considering it, not considering. I think that's that we start writing this into policy so we can put it out there so folks know how the board is operating.
Well, I mean, I think part of it too, and this is where I think the discussion and education piece is valuable, not about increasing your knowledge base, but with an understanding of what they're looking at on their end of things. They want to know what you're looking at. PRO has asked me several times, can you please find out what the board wants when it comes to, as an example, if a furloughee is a sex offender, high risk, moderate risk sex offender, and gets a new charge, or otherwise misbehaves on furlough, I don't have a lot of authority for wiggle room to negotiate on the interrupt. So prisoners' rights knows that if they've got a client who is in that position, that we're going to have to try the case, or unless they can show some real information that something improper happened. So they know that. It's the same with I think that's the mystery with you all as to what is your philosophy? What are the public protection items that are most important to this board? What are the lower hanging fruit that you will indulge and have? And I think what you'll find is if your pattern is disclosed or your philosophy is disclosed a little more openly, then you're not going to have to sit through long hearings where they throw everything at the wall, because they're going to know, hey, their focus is what this person has been doing. Have they been employed? Have they been doing everything else? Was this just a bad day, or is this a pattern? Just as an example. So, there's certain offenses that without, you guys are very victim heavy. And so are there certain offenses that involve physical injury to a victim that there's really not going to be a lot of wiggle room with y'all. It's like the same with knowing what your judge is. Ethically, we have to do our best to know how the judge is going to handle certain issues. So it's really, otherwise you guys are just going to get tons and tons of information that probably isn't even relevant to your decision and just muddies the waters. So that's why I think that dialogue is important. Mm-hmm. And if you said to me, Lori, make sure prisoner rights knows that they, any of these cases, without a doubt, we're not, there's going to have to be some real extenuating circumstances to convince us that we shouldn't revoke if it's, whatever it is.
Well, based on I want to finish up with the intro. Based on the last month and a half since our first discussion, and most of us have talked about this, if there's an interrupt in play and there's a reason for it that's explained, that's going to be the reason to deny parole. That and the reason for it that still exists. Yes, we will consider the other issues, but we're not going to grant parole.
Yep.
the cases that are important, you talk about being victim heavy, and the ones that we've been going to trial with Blake, and predominantly domestic violence cases.
Yep.
Which most of us have a pretty good understanding of the background for these, what's going on, the victim issues. And we're pretty hard pressed to continue someone on parole who's involved in that. And I don't think we're giving any mixed messages on that whatsoever, but those
would
are the
agree.
ones we're getting the trials on.
Yeah, no. I would agree. I mean, I think there's a clear understanding, at least in the discussions I've been privy to, what your concerns are in those cases. I think that is one area that I don't know that anyone could say you've sent completely mixed messages on that. Yeah, I mean, I think, and again, it's whatever your dialogue is as a board and what you guys determine is going to be, you know, and kind of the SDMF stuff too. I mean, it's kind of what you put value in, what you look for, what your focus is. And
I think the one that's hard for me is, so we can't do a parole, we can't violate based off of a technical, meaning
Yes.
drugs, alcohol. No, we can't. But if that's the pattern, because remember, we've talked about patterns before. So if this guy's a DUI 4 and then he's drinking again, then I don't understand why we can't violate. Like it's a revoke. It's a pattern. And then it's like what comes out is, oh, he's never been to inpatient. So we end up paroling the inpatient treatment. And it's like, okay, I feel pretty good about that. Like he's continued drinking, he's still struggling with drinking or drugs, put in any other technical violation. But the pattern is, and you can see the PO. The PO is just like, I've done everything. And this person just like continues to behave for the reasons that this person has been in jail since they were 13. Like I've read some of these cases, like first time arrested 13, first time arrested 11, right? Now the person's 50. And it's like, this is ages of the same behavior, yet we can't do anything because it's not really a violation. They haven't gotten a new crime and but the PO is like, it's the same behavior. That one to me, it makes me want to pull my hair out because that to me is a risk in the society because a person can get behind the wheel and drive drunk and kill somebody. So why we can't revoke based off of a violation? No, off of a technical. No, we can't though.
Yeah, we can.
We can violate on, I want to separate the technical versus the alcohol, because I think we've got two different things here. Because technicals, you can absolutely, I think it's that alcohol statute, which I know you've given a lot of education, Lori, on, is that you can revoke. We just got to have a good stance, good cause to revoke based on it and a history of it.
A lot of it comes back to the matrix that we are not using now that we're going to try to update. For someone who had committed technical violations and we use the matrix.
Dependent.
We could revoke if we had cause and we wanted to document the reasons for that.
Or their risk level. If their risk level was higher, you could.
But
I don't know. The boards I've been sitting on, it's like, oh, we can't revoke because it's a technical.
And I think that leads
The same behavior.
and that leads to some of the violation discussion, because I think I see where you're coming from, and that the board, most of the boards are very reluctant to revoke on technical.
And back to working with other departments, you can see, tell the POs like just wanting to stick a pen in their eye because this person is just doing the same thing over and over.
Mm-hmm.
And I'm trying to I definitely would side with the department because they're the ones that have to babysit these people.
Well, I mean, I think for all the reasons just stated, I mean, you can violate. I mean, a technical violation just means there was a condition that they didn't follow. And, those just require that you meet the evidentiary standard. And then I would say a smidge more, it has to be more of just, and also the self-harm. Is it just self-harm or is it, but again, potential risk to the community.
Right.
So,
Yeah.
you know, I think I can defend any of your decisions when they're founded in pattern-based behavior and ample opportunity has been given to the individual to fix it.
Mhm.
So
Yeah.
those decisions are, you know, that's an evidentiary, you know, standard that you guys can meet all day long. So I don't want you to get caught up and be like, is this just a rule violation? You get to look at the whole picture.
Mhm.
And I think the push by the legislature in general, just the flavor in Vermont and the judiciary's support of finding alternate opportunities for this individual to not come see you again.
Yeah.
And what does that mean?
Well, the board has gone through over its involvement to a lot of training over the years, which takes a look at some of these things differently. Someone who drinks at home who has an alcohol condition is quite different than someone who gets behind the wheel of a car again, who doesn't have a license. Someone who is an opiate addict who relapses doesn't necessarily mean that we're going to revoke and put them back in jail. There are other options
Right.
that we have to consider.
Right. Yeah, and I'd have to get the name of the cases, but I think that was one of the more recent concerns that I heard from the officers was someone who had a drinking issue or had something involved. And again, I don't have the case names to give you to look at, but maybe we can figure those out and do a case study at some point. But there were two cases that day, this particular day, that one individual was basically was revoked and put into prison to dry out, and the other individual had an assault, some sort of bodily injury style, and he was continued on parole. So taking those in a vacuum and not looking at the facts around them, that just seems odd. It seems odd that an individual that's self-imposed alcohol condition has to engage in drying out in an incarcerated setting, but someone who's, you know, physically injured another individual. And again, there's more facts I'm sure you considered in the whole situation, but globally, that's not the messaging I think you guys want to send out.
Right.
But
And I actually think this conversation is blending right into the next agenda topic about questioning during disposition of parole violation hearings, because this is something I wanted to bring up. I brought it to Lori's attention. I asked Lori, I think I mentioned it to you too, Dean, about how much questioning can happen during disposition, because we've got very clear rules during evidence that you can't go digging for evidence, you can't ask a lot of questions. But during disposition, I think I wanted to just look at the rules again, because I hear a lot of it needs to be just clarification questions, where to me disposition is where you're determining, okay, you already found guilt, they already committed the violation, you decided they committed the violation. Now disposition is your meat portion of whether or not you're going to keep them out there or not, or you're going to revoke. And I feel like prisoners' rights is always coming with a very heavy case. DOC sometimes is, sometimes isn't. And I feel like there's not a lot of questioning during disposition to clarify what is their treatment that's going to happen. Is this person doing to address their behavior? We had the case a few weeks ago where there was no talk about how this person was going to deal with anger issues when they had an aggravated assault that was pled down to a simple assault for strangling somebody. And so I just want to talk a little bit about the rules of disposition, because I feel like it's very prisoners' rights heavy in the presentation, and that's really what
It
you're taking in.
essentially has to be. Because you got a parole officer bringing a violation. And he, hopefully, if he's prepared his case and has come there, he's hoping for conviction.
Right.
So then he's going to jump over on the other side and advocate for the release and the treatment and all. And why didn't he do that to begin with? And why are we here? And yeah, prisoners' rights, that's their job, to advocate for their client and propose alternatives to our sentence. But I hear what you're saying, and I would like to see a little stronger suggestion from parole, but you know, a lot of times we see, well, violate and maintain parole, or it's like,
The other thing is.
you want one or the other.
I just struggle with disposition
So
because I feel like there's
disposition now, it's
very
changed a
little.
lot because DOC has attorneys representing them, which is great. And those guys are very good about presenting arguments for why this person should be revoked or not. And prisoners' rights advocates for their side of it, where in the past we didn't get that. And so we had to sort of draw it out of people. It makes a difference.
I just feel like
If they haven't made their point and we need to get clarification, yes, we absolutely should ask.
but I feel like, I don't know how board members feel, but watching these hearings, I feel like sometimes board members sometimes feel restricted from asking questions. So I wanted just a reminder from Lori of what's okay to ask during disposition versus evidence, because evidence has a stricter standard.
Well, I think the previous discussion that we had on this, correct me if I'm wrong, was about asking for information that wasn't presented to you. That's probably where it gets confusing.
Yes.
Because
Yeah, well,
if you,
that's in the violation phase, I think.
The evidence.
I mean, we used to do that all the time, and I finally said,
Right.
no, I mean, now I look at something, if it's not there,
But I think it's
Yeah,
being
but it's not my
blurred.
problem.
But I think
Yeah,
it's
agreed,
being
agreed.
blurred, and I just want to just put that out there because I think sometimes when Dean, you will ask for clarification questions only, and that to me is like, okay, so does that mean if I don't have a clarification question, but I do want to ask a specific question, I can't? So I just want to, what if it's a question about a treatment plan or something, but it's not necessary, a board member may not think that's clarification. So I just want to just put it out there of what's okay to ask for questions.
And they ask about history of supervision if it's not directly related to the evidentiary. I mean, it's not clarification, but this person has a history of XYZ. Can that board member ask that in disposition? Since it relates to either staying on parole.
Thank
not.
you. That's kind of where I was going, or
I mean, yes, I mean, you can answer the question. What it comes down to, you can ask all the questions you want. It comes down to what information you rely upon when you make your decision. And being clear about what that is. But if it's important to you to know, and again, this is back to the messaging. If it's important to you to know, has this person done this 12 times? Is this the first round? Is this a pattern that we're seeing? I think that's completely relevant, and you're able to ask about that. It's when you go seeking out evidence or information, and I appreciate Wayne in the moment where you're like, if it's not there, I'm not going to go looking for it. That's where you don't, that's where the appeals have been going about basically doing DOC's job and presenting their violation case.
another question I could see potentially is if prisoners' rights and the individual are presenting a residence to you or something, and maybe a question is, DOC, has this person ever lived at this residence? Because they're not gonna, the PRO is not gonna offer that up. It's just kind of that kind of information to just, I don't know. I just feel like there's been a lot of bootstrapping around not asking a lot of questions during the disposition part. So I'm just expressing what I see because I watch.
Well, and I would agree there is. In a case like that you just described, if prisoners' rights presents a residence, we're gonna ask DOC, do you have any information on that? Thoughts one way or the other? Would that work or not? They certainly have the opportunity, we give it to them to respond.
Yeah, I mean, prisoners' rights, as part of their job, it's to tell a different story and humanize the individual outside of the parameters of the rules.
Right.
So it's a much different look when the information is presented to you than these are the rules you impose, this is what they did, and this is why we think they violated. So
So recently, they've been bringing in occasionally someone that they're working with to help provide residents information. And so this person will testify that they've got a plan going forward. And one of the reasons we're holding back is because residents has been an issue because of condition 16. So when we look at this, is this a viable option? Sometimes it includes a transfer to another jurisdiction, which is not in our bailiwick. That's up to DOC whether they will allow that or not, for whatever reason. But we're asked to consider this residence plan that Prison Rights Office is putting forward. And DOC has told us that the residence has got to be approved and there's no residents. They're on a waiting list. Could be 6 months, whatever. We review the cases after 2 months for those that we put on parole to see what's new and different. But now we're being asked to look at occasionally a plan that's put forward by Prisoners' Rights. Then ask DOC, does this work? If this can happen? Sometimes they're agreeable and sometimes they're not.
Well, my argument to prisoners' rights all the time in those situations is present that plan to DOC
Yeah.
prior to you going in front of the board.
Yeah.
Like, I mean, have that
And they might have.
discussion.
They might have, Lori. I don't know that they have.
Well, I will say in general, and I give them a hard time about this all the time just because it's fun to do so, but in our 74s with furlough violations, they will, again, prisoners' rights, very effective advocates when it comes to explaining the human being and stripping off the criminal behaviors that you're dealing with. But they will often go into a Rule 74 and explain they were helping the aunt that had cancer. They didn't have time to call, and this aunt that had cancer, and then we had to go get all the food and groceries, and I was working part-time, and I just didn't have time to report to my officer. And they tell this really empathetic and sympathetic story, and I'm over there just objecting as to relevance in relation to the record because none of that was ever presented. So I just, again, without getting too far deep into legal advice, I just caution you all to, or encourage you, I guess, to ask those questions, because a lot of times I'm seeing that information has never been presented to DOC before the moment we're in court or the moment they're in front of you.
Yeah.
So,
And then DOC can't really approve or deny it because they've never seen it. I mean, that's happened a couple times where they're like, oh, we didn't know about this residence.
well, and that's if I see that there's a residence issue or there's condition 16 on there, I'm constantly looking at these people to see what has been done, what efforts have been made for this person. The Defender General also has individuals now that are working on case plans on their side of things to try to assist the DOC caseworkers. I mean, to me, it's a more collaborative move because there's people outside in the community that have more resources to find housing or to find other options.
I think that's what's coming forward.
Yeah. I mean, they're all really trying to offer that help. And sometimes I'll have people on waiting lists and we're trying to resolve a 74 and I'm like, hey, we've got a housing issue. And they will put money on their side of things into these therapists, counselors, caseworkers, social workers to help these individuals maybe try different things, which has been helpful. But yeah, I think at any point in time, it's always a fair question to ask if DOC was made aware of the request that was made in front of you guys. I think that's fair to ask.
Anyone care for a bagel?
Very good.
Donut.
Down to parole violation B. Is that where you're at? Okay.
I'm trying to.
I think that's where you're at.
So I find a serving china right there.
I know.
Peanut one.
Maybe to make sure I get it back home, my wife.
They start.
That's a really dumb question. What does it mean to be killed?
Bacon scallion, that's good.
Yeah, and their confidence, they could.
These cases that are coming in.
A panel,
It's
It's just
more
like
playful.
every day when I see the new one, I'm like,
Joe was there,
There's a
maybe
requirement.
somebody's an expert, like
Or-
the stuff.
Yeah, I bet.
Under treatment, division, and they go over the entire history. On some of the cases
A lot more.
we see, you'll see the case staffing is included.
And so they developed a whole plan of what should happen, what needs to happen, what programming they need.
Yeah,
all of that.
there's
especially
categories and
the
they
difference,
usually
though, they-
define what's going on in each category, like the person's history and stuff like that. And that's, and
Yellow.
They'll double down.
I wonder
Yeah,
if
that
the
was my
yellow
initial
one was-
impression.
Back. I don't know.
I don't
Squash.
I would- We might want to do
Cornbread.
this.
well, it tells you who they are in decision.
Is it a cornmeal one or like a corn muffin one? Oh, I've never seen it.
Well, we don't know
You haven't-
what the case staffing, the case staffing, decision. Sometimes it
Or
says,
put it in quarters. We could all sample
we
a
approve
yellow.
this person here,
The yellow bagel.
or we don't, and it tells you why. A lot of times on the referral summary, there's a little box and it'll say case staffing.
I'm so
report.
curious.
Okay.
So you check on that and you get the entire case staffing.
Just the.
Okay.
We never used to get that and it's nice that we do now.
Yeah.
Usually have
I
a
keep hearing
gives us
case
a lot
staff
of
and I'm like, I don't quite know what that means.
Yeah.
But
I just
I guess-
explained to her what it meant.
I guess it would
Yeah.
be kind of educational.
Yeah.
To have some education on what happens.
I don't know, the more I got into that.
I'm not seeing much
yesterday,
difference
You and I were
other
going
than
over that.
their record,
I
other
was
than
like, it tastes like a
plain
bagel to me.
7 people like us sitting in the room going, he's coming back to jail, done. And there's nobody there making that decision. Maybe you could tell. I let you taste that basically.
It's like dry bread.
Yeah, I'm not sure.
Have the PO.
It's kind of.
Ooh, that yellow
they have
bagel.
the scores.
It's egg. Egg bagel.
So it's got like more egg than the
Is there-
regular bagel.
There's a template that you follow that.
Yep, absolutely.
Right, bagel.
Like a lot of times, how many times you've been.
Doesn't taste any different. It's good.
And it says it in
Like a
the
rye
case staffing. There's categories.
How does it get
Yeah,
determined who
you
gets
get
case staff?
As long as it gets noted, you know what?
Back.
And then-
Violate automatic.
Yeah, we'll just make sure that it's.
So as long as I have all.
Whatever you want, that's, yeah, that's.
Yeah,
That today was your case staff.
Veggie and
That's bacon scallion,
Your
that's
local
veggie.
case staff, things with the facility can do it. That's changed. It's good.
It's like something like.
Bacon scallion?
Now they.
So that's pretty serious.
I don't want to put that 30 days.
They don't have to even do a local
Yeah,
case
'cause I
staff.
want to really hone out some of
Mm.
that as well.
My nephews are arriving today.
Hmm?
My nephews are arriving today from Norway, from home,
Yeah,
and I predict that I will be eating junk for the next 7 days.
Hey, Lauren.
that's why I
Because they
got
don't-
bagels, no junk. Donuts today, real food.
So it's gonna be Little Debbie
And.
and
Supervised caseworkers.
Hostess for the mostest. And my stomach is like,
Parole board has been ongoing.
this is gonna be a rough
Is it
week.
worse now than it was, or it's the same thing, or?
14 and 18.
It's the same. There just seems to be a
What
heightened
are they gonna do?
frustration right now.
That's my.
And
my
it's, I
dad's
don't think
funeral.
it's unique to the parole board versus the judiciary. You know what I
might
mean? It's just like
surprise
these
you
additional
I mean,
requirements.
They're here for how
I
long?
used to be at the
Just a
parole
week.
board, I listened to the case, I mean, I just wonder if it's the same,
Yeah.
but you really
healthy.
think you
Well,
pass
last
on
time when the
probation
18-year-old
says,
came by himself, I woke
get
up in the
parole
morning
Officer
and there
does
was
a
like
good job.
a stack of
Subtle,
$5
but
of
outstanding
Little
job.
Debbie and
I mean,
Hostess
I haven't
on
really
the
done
counter.
anything.
They can't get
He went to Walmart at
How they
10
want things
p.m.
up. You could tell.
Yeah.
stocked up.
The other guy.
They don't
just
get
about
them?
girl,
No, you
just
can't get
basically
that
say,
junk food. You
You
can't
wanna
get that
violate them.
in Norway.
Information.
Really?
Going on.
No.
Case
You can't
staff
have
is
food
paid for
coloring or
8 to 10 months or
additives.
whatever, with no
Very
ration.
healthy.
I mean.
Yeah,
it's
healthy
live
food. Yeah, healthy
Incumbent
food.
on the corrections to before.
Can they take food
And
home?
there's
Yeah.
somebody, the case
Okay.
staff, I think the one was done not that long ago, was gonna.
They can take home little Debbie.
I keep looking at my phone
Right.
because my sisters, they
Feel like
lost their
4 months, you know,
suitcases.
Whatever.
And they had to get an American number. So
So
I
looking,
keep
but
getting
he
these
had
British
everything
Airways.
lined. If
We have
go over,
located
could
your
tell,
luggage,
watch it.
but it's
Well, once
still
it's
in
on,
London.
this interrupt, we're gonna let him out. So I remember talking to Dean. When we wait for 3 or 4 months, when he didn't go out now, it's because he interrupt, which he already took care of. That's where my frustration would be on the interrupts.
I am so
understand-
gonna touch.
I
it.
understand the interrupts. I was part of
I'm
it,
gonna put my
but
fingers all over.
we're not, they put down, so we're gonna hold them in there because of that. I have a problem. I think, with that.
Yeah, well, I mean, it undermines the consequence they received at the beginning, even if they rallied.
Right.
You know what I mean?
Yeah.
If they rallied and, but that's, you know, but we defend the length of the interrupts and we get them
Yeah.
upheld. So there's some message there that you
When
gotta
the-
put.
When the PO says on the hearing, if he wasn't on a interrupt, we would recommend them for parole, and
Sure.
that's not uncommon. And so looking at it, so wait a minute, he wants to recommend them.
Well, and that's,
Yeah.
that, you know,
I
as
know.
well as anybody, that's just them following the they're
I
not
got it.
allowed to come in and
Exactly.
go against their policy.
No, they can't.
Yeah, so they have to go that route, but they're telegraphing obviously to you that they feel
Oh, yeah.
their ducks are in a row. Yeah, and in those situations, and there are times that the department has reduced the interrupt based
Yeah.
on our
Yeah,
recommendation, and to say, hey,
Yeah.
or they've met some milestone, something's available to them. We've got to let them out early to go meet
Right.
that, and the department is more than willing.
Or
to
they'll
consider
say the interrupt or resolution of the criminal charges, whichever comes first.
Yeah, I've heard that one.
And the
Yeah.
other thing is too, is about the complaints about the parole board. I mean, I can remember Rick saying the same thing.
Yeah.
I said, what are they thinking? Well, back in the day.
Yeah.
But, I understand people, but it's, that's just the nature of the beast. We
Yeah,
we are gonna agree all the time.
Yeah, and I agree. Yeah, I don't think that's the case. I think there's just a heightened scrutiny on confrontation on a number of items that has just upped the ante, where you can't just come in and have a discussion about this individual. They can just report what's been going on, and then you guys ask your questions. And it's risen to such a procedural level now that it just has just put more pressure on the system, if you ask me. But
If the PO does his job, the due diligence, he or she, I mean, it's amazing what can be done in a hearing. It's the ones that don't do their due, that just come in with nothing.
Yep.
Of the problem, but I can think of one PO especially, whatever I look forward to it. Crosses his T's, he dots his I's, he has everything, past history. Lots of not even a question for it because he's done everything.
Yep.
Those are the ones you can make a decision relatively easily based on the information we have presented to you, as opposed to why do you want to violate it for? Oh, because I want to.
Yep. Well, and again, the trend on new hires, turnover,
Yeah,
people
absolutely.
moving to other positions. There's a lot of pressure. You make more money if you're in facility now than in the field. There's just the turnover, the retirement,
This change on July 1st too.
it's just constant, and the pressures to evolve on the daily are just a lot.
Oh, yeah, I listen, believe me, I understand.
You asked about touching. I didn't.
But no, I don't think it's much
It's been a big help though, having them be represented.
Thank you so much.
Very good.
It's changed things a
The
lot.
trust.
Well, and there are times when our team
Very good, thank you.
Thank
I would say it's not lacking. I think
Hey,
the,
Lynn, they're really
ribbing
good about
is- it's definitely there. It's still gonna be knowing that I did nothing.
and I know we're not this. You don't have a test in a row. And so we
Sentence interruption that we
push
have,
back on that too, for sure.
6-month early release.
And then when I get a complaint about something, I go over to the
Like those
to the
cases
guy
because
and be
usually
like,
they're
what
pretty
happened
squared
here?
away.
Why is
It
all
really
fired?
bothers me. It still does. It's like,
Then it's 6 months.
Try to understand why the case was presented right.
You sound like Pete,
Yes.
Wayne.
Wow,
why
do you
do
not
we
like,
have the authority to say,
do
Johnny,
you not like,
Violations with interrupt.
You sound like Pete.
a good behavior, that thing where they get good time?
Yeah.
Do you not like that either?
Everybody's pretty-
Totally.
no, good time I could see
Yeah.
if they're in a
Well, again,
facility. That I
it's
understand,
nothing-
you
Well,
know?
what about work?
But work was.
I can't counsel you guys in hearing,
Jail
but
method.
if
So the
you
judge wants you to do a year,
come across one of those questions,
and they know you're gonna go to the work
you
camp.
know what I mean? When you're in deliberations,
They give you a 2 years.
I'm allowed to talk to you then.
All
You
this-
know what I mean? So if someone has a concern about something and that what's going on with the interrupt or more, you know.
Now it's
You're-
He goes for sentence reconsideration.
So I want to make sure
It's a
you,
good time. It
Which-
helps
whatever way you go.
control the population. But the judges know this. They want to give you a year's sentence.
I
They
see.
will give you 2 years.
Yeah.
So that's, so don't, so.
No, but Wayne was saying 6-month PER.
The worst case scenario these people are on is a phone call every month. Yep, I'm good. So
Wow,
what?
I like the early release cases because usually they're pretty squared away. Like
Yeah.
they got stuff going and it's like a success story sitting right
It
there.
is.
I like those, Wayne. That's what you think.
You don't like them?
He says it bothers him that they're.
Ever since I started this whole thing, I'm like, why are we doing this?
You don't remember that discussion when we were doing the whole revised PER thing? Him and Wayne, him and Wayne. Oh my goodness.
Wayne and Wayne.
Pete and Wayne were the ones that were all no more than 6 months because who are we to override the judge?
Well, I remember those discussions.
I was gonna say,
They were wrong.
They were very disgusted.
Don't bring up something that I had on discussion. I don't know if it involves you or not, but
I don't remember
the-
the discussion.
That's what,
the new thing now is they don't want to come on parole because they don't get good time.
that's right.
Yes, I've seen a
But
couple of those on.
Can we not dangle in front of them the 6 months early?
Oh, yeah, they're told that.
Oh, they know that already?
Oh, yeah.
Oh,
Supposed to.
And earn time almost,
more.
it got through the House this time for parolees. For this session for parolees, it was stopped in the Senate. There's gonna be a working team with justice oversight to look at potentially adding it for parolees.
The difference, Lynn,
But
is
is it more than 6 months in a year? How much do they earn?
7 days a month. So
So
7
7 times 12,
25%.
84. So
The
2.5 months they
but
get
the
in a
downside
year.
is-
Holy,
if they screw
bananas.
up, we're not gonna give them early discharge, but they'll still get their earned time.
yeah, they can't mess up.
So.
The one
big
thing I said, the judges
so
understand,
complicated.
understand the days.
That's why
That's why they will,
This
the
is like,
the judges will, they know,
Game
again,
chicken.
the 2 years, they want the guy to 1 year to go into work camp.
yeah,
They'll
yeah,
give him
yeah.
the 2 years. So I mean, it's all how you wanna.
Can I just say again, thank you for advocating that we don't calculate the ERT if this is granted. I really appreciate it.
That'd be horrible.
Can we go back, is our break done?
Yeah.
Seems we've
Yeah,
gone.
we're done.
Yes,
a
Shirley.
Break is
gazillion
done.
different
Sorry about that.
topics. And maybe go back to our agenda.
Okay.
Yes.
Put these away from me. Take these, please.
So I think when parole violations, responding to violating behavior, create guidance and decision tool.
Mhm.
I added this to the agenda because, it's in Dean's condition memo too at the bottom, but, I've kind of taken on the second task from Richard Stroker around starting to take a stab at a decision-making tool for parole violations. But with that, in some of the conversations, I brainstorm a lot with Lori. And really in some of, I think what came out of some of the Q&A sessions with DOC staff is really around how to respond to violating behavior for parolees. And I think this is going to come up in the conditions conversation too as well a little bit. But really, DOC does not have an outlined policy on how to, like, when and if they should grad sanction somebody who is on parole, when they should bring them, what behaviors is the board really looking for to bring them before the board for a reprimand, when to bring them for a violation, kind of maybe giving some guidance out there to what does the board want DOC's parole officers to respond to at the lowest means possible? Because I think that's the overall goal of supervision, is to respond with the least restrictive means first, and as it escalates, respond accordingly. So really talking about finding staff with some guidance around parolees, because there's guidance for furloughees, obviously, because they're in control. And they've been kind of trying to mimic that, but then there's some questions from staff about that. Am I
But are
on
you
the right
like-
track?
Are you fishing around
Sorry.
for like a flow chart of sorts, like where like person A, if he does this, this happens. If this happens.
That's kind of
this
what
is
they have
happens.
for
Like,
furlough, and they have in rule for probationers. there's really no set guidance on how to respond to when somebody allegedly violates their conditions of parole. There's really no process or guidance out there for DOC staff. They're just guessing, should I bring it for a reprimand? Should I address it as a grad sanction? Should I bring it as a violation?
So I don't really know this, but
Yeah.
when they get brought before the parole board, who decides? Do we decide if it's just a reprimand, a violation, or a revocation, or do they come up and they bring them before it and say, this is what we're asking for?
They bring it before, and that's what they're asking for. So they're either bringing
Okay.
it before as a reprimand hearing where attorneys aren't involved.
Okay. So no, there's.
And then the board decides whether to treat it as a reprimand or treat it as a violation.
Okay.
Or they're deciding to file it as a complete violation. There's no real.
So the reprimand process is something we developed as a means to have a non-due process hearing with the understanding that it would only result in a reprimand. So if the PO wants to bring the offender before the board for some relatively minor issue, they can do it as a reprimand, and it's just the board, the PO, and the offender. And then we will listen to the PO and their request for a reprimand. And if the board agrees to accept this as a reprimand, proceed, talk about it with the offender, and then we may add a condition or something, or do some other
And then
process.
that reprimand can be used in future violations.
It goes on their record as a reprimand, but they're not revoked, and they're not going to be revoked. If we look at it and occasionally, but not very often, the PO will come in and say the person has committed a new offense, and we look at this and we say, boy, this is potentially pretty serious. We're not comfortable with this going forward as just a reprimand. We haven't talked with the offender. So the PO then gets the direction that it's up to them to bring this forward as a violation.
And
Then it
lawyers
becomes
are
a due
involved.
process hearing,
Okay.
with the offender being represented. And we tell the offender, if we're recommending this, we're not talking to them because they're entitled to be represented by an attorney before we have any discussion with them about it. So it's a shortcut way to get a reprimand without having to go through a longer process.
That's what I didn't know if they just bring any
Some
sort of
POs use it regularly.
problem
It's a
and then.
very
we
good
decide.
supervision tool, and others don't use it at all, but it's there.
But then we would look at it, if then they came with a violation, oh, they had two
Yeah.
reprimands building up to this. So
Okay.
there's your repeat behavior.
Right.
Yeah.
And then based on the violation, it's either revocation or just continue, but it doesn't necessarily automatically come in as a revocation case.
No.
Okay.
No.
I just wanted to make sure of that.
And I think some of where I'm bringing this up too is for a while, I had to have a conversation with DOC central office because they didn't believe that reprimands were happening. And because the numbers were so low and they didn't understand the reprimand process, they were not really understanding what the board wanted. So that's why I'm just throwing it out there as another way.
I guess my first question, MJ, is that our part and our role to tell DOC what our schedule of fines is? Shouldn't they, some administrative branch to their field, say, okay, if you have this, and this, you bring it as a violation. If you have this, bring it as a reprimand. If you have this,
Yeah.
treat it as a sanction. Why is this our role
These are
to
your
tell?
rules. These are your conditions.
Well-
This is how you handle the conditions.
Well, it's our,
DOC will look at it differently than you potentially.
it's our law decisions, but what I'm hearing MJ say is she wants boilerplate from us to say, this is what you should bring to us.
But as a board, don't you want DOC to supervise the individuals in the fashion that you are hoping that they're going to be supervised in? I guess that's where I'm confused.
Well, that's why we
There's
put the
gotta be a
conditions.
Flexibility though.
Right, but with conditions, your condition could say one thing, but what does that mean? Like programming to the requirements of your parole officer. That leaves it so open but so when do you want them to come back? After they've missed one appointment, 10 appointments?
We shouldn't have to tell them.
No, but
No.
I'm using this as very simplistic, but I'm also saying that it goes with some of that conversation of.
In some respects, making it more complicated than
Yeah.
it needs to
This
be.
is getting-
When we developed the reprimand, we had discussions with POs at the time and their supervisors. Here's a tool that you can use if you choose for a minor violation, rather than bring all of them forward as a violation.
But they
It's up
still have to
you.
come before you.
They still, but they don't.
Yeah.
Graduated sanctions and furlough, they don't have to. They make the determination as the supervising officer that
Yeah.
you've only
So
met
there's
this
your
level.
first.
So
Yeah.
So if you don't have a chart in there that says you guys have authority to take care of these 3 steps before you waste our time,
Yeah.
you're just gonna see more cases. That's all.
I
But that's your
I would
prerogative.
venture to guess, Lori, of all the reprimands we've had, it would be less than 5% that we sent back for violations. So they're doing a good job of figuring this out. The ones that come forward.
right, but they're
And they're-
figuring out in the dark a lot of.
I
the
don't think
time.
MJ's questioning that. I think MJ is just saying, do you want to issue, and it's a resounding no so far. Do you want to issue some, regulations that say this is what happens when you make a determination of these and you don't need to come before us. You guys can handle these things. If it gets to this level,
other
you
words,
definitely want
Have a
to.
reprimand without a hearing, like an administrative.
Well, again, I don't know why I don't understand that. I guess the
Yeah,
point
I
of
think
the
those
officer
two.
coming to make a pitch and just say,
And
slap
that's
him on
fine.
the hand.
I
and
mean,
give
I
you
like
guys
that
the
idea.
blessing.
That's a different story, but to have an option to present us with a reprimand request and we handle it administratively without a hearing.
Yeah, but I think sometimes the officer uses it to make the person scared
I think it needs to have a hearing.
because.
Right, I think it needs to have.
Because then you
Because
say to them
otherwise,
very
what teeth
clearly,
does that
we
have?
might make this into a violation.
Right,
And then that scares the
Yeah.
person. And now the PO feels a little bit better because the person
Right.
kind of got yelled at by the
yeah.
daddy.
They have to sweat bullets a little
You
bit
know what I mean?
if they get violated.
If,
They use it as
This
a,
is my topic. I just want to just intervene at this. I guess everybody's taking what I was trying to get at is nobody knows when to bring a reprimand before the board, and nobody really knows when it rises to a violation. And I think it's some of that education to staff.
Mhm.
And DOC Central, if you were leaving it to DOC to do, central office is messaging one thing, staff are doing another. Nobody's on the same page. Where if the board looks at what are
So what's the best way for us to clearly explain to them what we,
so the
it's
question.
back to Wayne's list.
Well, it's a list or it's a chart or it's some kind of escalation kind of thing and just
A flow chart.
I'd be willing to start to work on something like this, but I don't want to waste my time because I feel like
Can't we
there's a
take,
lot of
can't it be started, can't like the starting of the drawing board be based on the reprimands that have come in? Which cases are looked at to be really sound? This is exactly what we want to see. And then start the list based on that. And then the ones that we violated, these are the ones we don't want to see.
Or these are the ones that are too heavy.
Right,
and need to be
exactly. And
deposited.
start there to create some kind of guidance.
there are a handful of parole officers in the state that use the reprimand process very well.
Mhm.
I would gather that list and say, here's an opportunity to learn from these experienced parole officers who use the reprimand process very successfully. They figured it out. If we need to put something in writing to support them or whatever, that's great.
I think part of I am going to just be blunt and put it out there that I think part of the reason they're doing it is they want some method to show the cover. I think part of it is one, either they want the board to talk to the offender, the parolee,
Mhm.
or they just want a way to kind of document it a little bit because they don't know. I think in some places they're at a lost cause of what to do with these individuals.
Well, I think the
Well-
person
Because
like
there's no-
slipping down the slope and then they kind of get yelled at by us. And then I think at least if you talk about like Dunn,
Yeah.
right? Dunn uses reprimands all the time and he likes to use them
Yeah.
because he says after that, then the incarcerated individual, well, they're not incarcerated, but their supervised individual then toes the line more. 'Cause it's like, oh, I got in trouble. It could get worse. Like they're watching me.
I mean, I mean, there's a whole level that precedes the reprimand from what I'm hearing, correct me if I'm wrong, but I'm hearing POs come in and say, you know, I've issued grad sanction, grad sanction, grad sanction. I didn't even know that was an option to a parolee, but this guy's grad sanctioned and this guy, I've issued 7 grad sanctions and now I'm bringing it as a reprimand.
So that's what I'm trying
They can have dual status. I mean, don't assume they're just on parole. You've got people that are on parole and
Oh, yeah.
they got dual status. I got people incarcerated that are on probation.
Yeah.
So.
So I think, and that's where that's why I'm bringing it up a little bit and bringing the conversation up, but it sounds like I've got 10 million heads up here as I'm bringing it up, so.
We want a flow chart. I want a flow
I think it makes sense to create some sort of guidance because I think it can be used a little bit more effectively. My mind already jumped to how can we create that, but
I think it's, again, putting it out there, what's the expectations of what is the board expecting from folks? I think it can also be more clear, and I'm gonna have this conversation again when we hit conditions in a few minutes and that kind of thing. I think the more we can message, the more it's like the board is here and this is what they want, where a lot of times it's like, it's the board. And well, it's a last resort and maybe
Well, I mean, it
not
certainly
the
sounds like-
the board, it's just the board is not always figured into the picture when it comes to like the open meeting law. We were kind of never thought of. Sometimes we're not thought of in a criminal justice initiatives and so forth, and where a lot of these issues hit the board too, or you're experiencing it. So I just want to make sure that one of those things we're trying to
Well, and certainly
educate.
in our manual too, where we address reprimands, we could certainly further define what our expectations are there.
And that's what that was kind of more of where I was thinking, is responding to violating behavior as a whole.
Yeah.
And is it looking at the philosophy of the board and how to treat when somebody breaks their conditions of, is it the philosophy, really talking about the philosophy around that of, is it the philosophy of the board to have it treated in the lowest level possible, which I assume it would be.
Right.
And so forth, and really just expanding that to like, this is what, and then this is when it rises to be a reprimand. This is when it rises to a violation, that kind of thing, and really just exploring that, because and that goes into, and the next thing about the manuals, I think sometimes we have policies and procedures, but we don't also talk about the why sometimes. So, in looking at some of that.
A big undertaking.
You mean
That's a big
talking about the
undertaking.
why?
Well, like when we get to conditions, when you look at what I proposed for a change in the chapter, you're going to notice that I expanded the why and kind of tried to add some philosophy around condition setting, where there was none in the manual before. It was just the list of basically our conditions. So it's more of that kind
But
of.
are we required to do that in a manual? Giving background and reason?
I think it's always good to kind of let folks know in your policy
It's not
that,
a requirement, it's just whether it makes good sense. Yeah.
yeah, I think it's where it makes sense.
This opens up the interpretation and the wormholes for me and my colleagues to go flying in. So if it's pretty clear that this is what's gonna happen, no one can come in and say, well, you could interpret that to say that was gonna happen, not that. That's the biggest difference.
Okay.
And really kind of closing some of that, because I think there's a lot of, I think in our manual, there's a lot of areas that are left to open to interpretation, because it doesn't necessarily specifically say some of that.
I recently made an argument on your manual in relation to something that doesn't say what it applies to. And I won only because it was in a section that could be interpreted to fall under, but in another section, you referred to it only applying to the revocation. And the judge deferred to my explanation at that point in time, but it was thin.
I was saying you were psyched about the wormhole.
I'm always like
Yeah,
about the
we were talking about, like, well, that doesn't apply to those hearings. And she's like, well, it does. The judge took it. I'm like, okay.
Yeah.
So I'm like, okay.
Exactly,
maybe we
because
need
it didn't
to
say it
tighten up.
didn't. It didn't. And the judge is like, well, it was under this part, so it could be interpreted. And I was like, yes.
It was like I think it was in deliberation and voting, which is really focuses more on parole hearings, and we don't also hit on a lot of our other hearing types.
Well, a lot of things have evolved since we put that together.
That's why I have the next topic. So I guess the question, before I go to the next topic, is around responding to violating behavior. Before I take on just a decision-making tool, is there interest or guidance around looking at the reprimand, looking at the whole thing together as responding to violating
I'm looking
behavior?
at it from somebody who supervised these people. They say, well, we want to give you a reprimand, but then if I'm brand new PO, well, wait, what is a reprimand? I would think having some kind of guidance to help would certainly be something I would look at as.
And I think it would also help guide DOC policy and some of that supervision as well, because there's not a lot of. I'm going to start going through some of their policies too, like on community supervision. There's not a whole lot of guidance around parolees and how to supervise parolees.
Oh, there won't be in their guidance because you guys are under a separate statute. So they're going to defer to you subject to the conditions of the parole board. That's what the statute said.
Yeah.
So they won't, because then they're making effectively rules for you guys, I think. But any suggestions on any of those, I can certainly bring to them. I think the thing on it's up to you what you guys put in there for guidance. I think you will narrow down, and it sounds like to me the biggest thing is that not all of the POs and all of the jurisdictions understand. And I asked that question in the group I was training. What do you guys do before you get to what do you do? What process do you go through before you get to bringing them for a violation? And only half of them mentioned reprimand. The other half were like, what do you mean? There's something else we can do type thing. Yeah. So I can also see,
Well, and you think about, when we started this maybe 10 years ago, the people that were doing it then, most of them are not there now.
Yeah.
Didn't get passed on.
Yeah. Definitely, as far as, these other items, it's something that I would, I get to talk to the DMs usually once a quarter. And that's certainly something I should bring to their attention, that there needs to be more training and or discussion on what they do with parolees prior to bringing anything before you. Because there are some, it seems wasteful of your time. It sounds like you guys aren't too concerned about it. But I'd hate to waste your time bringing something forward that is going to go you guys without a doubt are going to say, no, that's got to be a violation. As opposed to the reprimand piece.
One of the things I was going to suggest is that when we talked about this in general at our training last month, we discontinued our matrix for obvious reasons, but it did have some good issues that went along with it. And I think one of the suggestions that Richard had come up with is developing one that uses our SDMF guidance language, mitigating, aggravating, that kind of thing. So when we are in a violation hearing, a simpler one, obviously, for less categories, but have the same mindset go forward in the violation hearing.
And the judiciary wants to see that they were given the opportunity to provide mitigating circumstances, or the department was allowed to show why it was aggravated. Then that's why we had to update DOC policy on that, because they didn't have any consideration for those factors in policy. So the judiciary's flair is that to make sure this individual knew what they were facing and had an opportunity to fully explain why they did what they did. There may be an occasion that an individual did disappear for a little bit because they were caring for a sick family member and didn't handle it right. As much as we might think that'd be silly, it does happen. So that may be important to you guys to hear that. And it may be, you can pick up the phone or send the carrier pigeon. Someone needs to know where you are. But however you guys want to, exactly.
And I think this would be a great opportunity with some of this is to use this, because the big portion of Richard's technical assistance is around violations, and not just around a decision-making tool, but I think having an expert help draft this over his next 2 or 3. I think he's got another up to 3 visits he can come And
We're
I
gonna
think this
take
is a great
advantage of it.
opportunity to take advantage of it.
Good.
But what do other jurisdictions do in this venue?
I think this is the hard part is a lot of the other jurisdictions have the parole officers are underneath the board. They're not separate. They don't have, DOC doesn't supervise a lot of the different jurisdictions or the board is part of DOC. I think that's
It's Vermont is really
unique.
odd and unique and well, the buzzword, it's set up really funky.
So,
Typically, parole officers would have the authority to sanction and or reprimand on their own prior to having to come to the board. Like the board is like behind the dark door and you don't, if you get to them, it's super serious. Up until then, I get to handle you like I would furlough. So most of the other jurisdictions have what that authority is built right in to their process, but no, Vermont, I mean, DOC is placed under the Agency of Human Services in Vermont. I mean, need we explain anything else? So they really should be in most other states, almost all of the other 49. They're under the judicial wing.
Or at least public
Public
safety.
safety.
Yeah, or well, either or. Yeah, but
anything else on that? Or the interrupts?
Oh, so discussion around how to update the parole board manual. You kind of skipped over that. I just wanted to, the manual needs to be looked at completely. And I wanted to talk with the board. I think some sections are good. I think I've started to update it. I've started to bring it before the board before. It's going to be a huge undertaking. So I'm just looking at how we want to do this. Do we want to do like a chapter a month or a couple? How do we want to try to? I also been looking at the structure of it and the ordering, and I was gonna maybe propose a new ordering because we go from parole eligibility to pardons to I want to try to make it flow a little bit more like parole, pardons, different sections. So I just wanted to just
A lot of it.
brainstorm how to
originally
update it.
Set up sort of in concert with the order of statutes.
Yes.
And so first statute applied to this.
And we know that order is not always.
So there's no magic to what
Okay.
order we use.
Yeah, so I just want to,
Yeah.
how we want to tackle it, because I think I've been starting to make changes to it. I brought them before the board before. It's just, how do we want to do it? Because it's going to it's going to take a bunch of time.
Should we do another like subcommittee?
I don't know. I think you're looking at it for what you're doing, MJ, looking at it yourself and then go get like a couple pages of a meeting or a chapter at a meeting.
So, but what I've been doing when I have time, I've been just reading it and making changes to what I see as procedure that's been happening and what's been changed in meetings and so forth. So that's why I was trying to figure out.
So my suggestion, and I'm sort of going back to when we first developed this, there was nothing in place.
Yep.
So we had Bree Salem from the AG's office, had our consultant from EPAI, and that time it was Peter.
Yep.
And myself that worked on, and the consultant and Marie and Peter that did most of the organizational part of it.
Yep.
And then presented each chapter to the board,
Okay.
reviewed them, with the understanding that as things changed and needed to be updated, we would,
Yep.
as a board, make those changes, all would review it, and then
Yep.
upon agreement, that would become the changed part of that manual. So my suggestion would be, if you want to look at reorganizing chapter by chapter, maybe the
Okay.
first step would be to give us an outline of where you think each chapter should land in this revised manual.
Okay.
So if you're going to have a different order for violations versus hearings, whatever. And then from there, go through each chapter once we kind of approve the order. And if you want assistance from the board, we can certainly have people that are interested.
Yep.
Want to volunteer to help, we can make that work too.
Yeah, I'm more looking just
But
for
it would be
guidance.
good to
and
get the
how to-
outline started.
Okay.
Yeah.
That's easy.
Yeah.
The new table of contents is the easy part. It's just, and then it's gonna be at these meetings, it's just gonna be a lot of, it's gonna be a lot of reading, a lot of work and comparing. And the other thing trying to figure out is what's the best way to present the information to you. Cause I like to use word track changes, but I don't know if that's easy to read or if it's do it more of the statute way of when they update statutes of crossing out and putting in new colors and so forth. So I guess really looking at what's the best way.
You pick the best way and let us know how it goes.
And then,
And then we would get that in our agenda packet to review before the meeting.
yeah, I'd probably give it a lot more, but I can,
Everybody okay?
Sure, that's fine.
and I think just also knowing that some areas may not get updated as quickly, like the responses to violating like the violation part may wait until we're done with Richard, but I just want to, I don't want to also piecemeal it and approve a chapter. We could put it out by memo, but I don't want to like do the manual like 5 times. I don't want to do it 5 times. So I think that's where I'm struggling too of.
Yeah.
I don't want to confuse folks by releasing like 5, 6 different manuals in like the next 6
No.
months. So long, if that makes sense.
Good.
I think now we're on furlough interrupts, if there's anything left to talk about.
I think we're pretty good on that. Yeah.
I think from an administrative portion, I just want to make sure everybody's clear on how, I think we talked about it, but I don't know if there was a clear that it can be considered. I want to know what clearly from the board, how you're considering the interrupts. Are you, because at one point, Dean, I think after the 3 of us talked, it was, if they're on an interrupt, we're not going to override it. So is that what the board's doing, or is there an opportunity to possibly I just want I'm hoping for a clear decision. So it's,
For the most part, we are not going to be paroling people that are on an interrupt.
so for the most part, so it is an option. So is it an option or not an option?
I don't think,
Be the only reason.
exactly.
That's
Yeah.
what we said. We said that
Okay.
like 3-way sideways.
No.
But the reason they're on the interrupt can be.
So for example,
Which is
if you
usually-
get an interrupt
Right.
where there's 6 months left, and in the packet, you're learning that nothing has been prepared yet for release. There's no plan because they're waiting for the interrupt to be up. In some cases, a few months before the interrupt is up, they begin the planning. So unless the PO comes in and says, you know, the criminal charges have been resolved, he still has 6 months left in his interrupt, but we think he's ready to go at this point. Obviously, I would consider overriding that, but otherwise, no.
Okay, so so there is an option to override and interrupt based on the circumstances of the case. 'Cause
Yes.
Yes.
Okay, that's what I wanted the board to be clear on, because I think at one point it was clear that we weren't overriding any interrupts. So I just want to make sure that if that's what the board's philosophy and what you're going to do, that it's clear.
I would also say that if there's only 30 days left, that one has a strong possibility of getting out. If the criminal charges are taken care of, if there's a 16, like if they have a place to live, if they have a job, it's just like anybody else on a minimum.
But I don't think we're gonna hear any of that.
We let one go, Pat and I can't remember who it was last.
All I'm saying is if the department's coming in and we're hearing a case that has an interrupt still in play, if that's their concern, that's where it's going to end as far as I'm concerned. I'm not going to.
Okay, so now I'm confused.
This is where I've been.
You don't have to. I mean, we'll
I
figure
have to
this
do
out.
the minutes, so yes, I do have to understand.
Well, no,
Each case is going to be different.
so each case is going to be different, but I'm hearing 2 different.
Well, let me try to make it very clear in terms of my.
Can I please finish, Dean? is there an option to override and interrupt or not, based on the circumstances of the case? I think that is the question at hand, is there the option or not? Because I'm hearing in one sentence there is, and I'm hearing in another, no.
Because
She's not looking for that. She's looking for a simple answer. Yes, there is.
I would say yes.
That's what I'm asking for. Simple as that. We're taking it way both ways.
Nothing's ever absolute. So I would.
So is it the
Yes.
board's philosophy to, thank you, that's what I'm asking, because I was hearing two different complete things. I guess I must hear differently, I'm sorry.
No,
I feel like I hear differently all the time.
I think we have a pretty good understanding.
Well, it's a burden to overcome. That the presumption is gonna be the interrupt's gonna stay in place, but mitigating circumstances or other information could, like, 30 days is all that's left, could make a difference in that.
So the answer is yes. There.
But
There you go.
There has to be an option to override it. You can't make a hard and fast.
Okay. Thank you, because I was hearing something different from you in a different day and also in this conversation. Thank you for clearing that up.
Good. I'll never speak of it again.
we will next month.
Oh, you're kidding. Okay. Risk reduction programming and community updates.
So I had a conversation with Kim Bushy, who oversees the risk intervention services for the department. The department is moving away from risk reduction programming in the community. Due to there are very low numbers of individuals enrolled in RRP in the community. They're looking at more individualized treatment in the community for individuals, and they're looking at how they can better use the funds when they're out in the community. So there's not going to be RRP groups within the field sites because they're very low numbers. They're actually going to be looking for whether they go into individualized substance use treatment or anger management with a therapist, or how they're doing it. And if you'd like Kim to come talk more about that, we could put that on our list too, but she just wanted the board to be aware. And I also expressed to her, which I thought was kind of the way the board's thinking, is whatever the best way to meet the needs of the individual, regardless of if it's in an RRP group or if it's in individual IOP, whatever was the best is what you're gonna want for the individual.
And my understanding is they have funding for this, correct? That's what I was told.
I don't know what kind of funds they have. I don't know all the funding, but they do have. They're trying to take the RRP funds that was being underutilized and putting it more into community providers.
So what has changed with the required programming in the facility? Which was?
Nothing that I'm aware of. The facilities isn't changing. They're just not calling it RRP anymore. They're calling it risk intervention services. But it's the same programming that they've always been getting. I don't think there's any changes to facility. They're just getting rid of the.
Well, some are triggered if they're starting to approach their minimum date or their eligibility for some sort of release.
Yeah.
Then the question is, are they held past their minimum to continue with this, or can they be released into a community-based provider? And instead of having those locally, there's going to be separate options for the individual to do it in the community, but it won't change anything leading up to.
So similar to the interrupt process, sometimes we'll get a case of an individual who's incarcerated and they've been case staffed to go beyond their minimum to complete their program. So we're still seeing them until they complete the program.
And I think that depends on what kind of programming needs are, and the department should be telling you what those programming needs are and why they were, it would be in the case staffing, why they were overrided, probably to stay past their minimum.
The question that comes up from time to time is, why couldn't I be doing this in the community? Kind of thing.
Yeah,
And that's-
Yeah, and it depends on what the risk is, what the program required, what their sentence required. Some of the sentences, depending on the offense level, require certain programming. Some can't start until you're about to transition out. Some are focused in transitioning you out. So it kind of depends on all of those. There's a lot of moving parts in that.
And I think the frustrating part sometimes is that the PO or the caseworker can't always tell you why, and I think that's where hopefully some of these, the case staffing may be able to tell you why.
It's gonna be cognitive self-change or RRP, now it's gonna be RIS, now it's gonna work.
Mhm.
But it's the same program.
And they're called risk intervention
Yeah.
services
Yeah.
now instead of,
That's a general program.
Yeah.
I got it.
And it also encompasses not just programming, it's also, they're looking at it more into
Holistically.
the education piece, the vocational training, it's the more encompassing everything all under one umbrella and not just looking at education in one section and
Got it.
the other.
So in our report now, a lot of times the PO will say he's gonna continue IRS in the community.
That's gonna be changing.
That's gonna be changed.
It's starting,
Okay,
it hasn't gone into effect now, they're moving away from this.
okay.
it could still say that, it just won't be DOT
It won't be a group.
localized, right? It could, I mean, and it could be an outside provider group. But it's not going to be necessarily contained at the field office by DOT.
Or like the Clara Martin's group, we heard that
Yeah.
recently.
Yep, the obviously the push is to get more people into what their need-based,
Rather than a general
rather than, yeah.
And what interven-
catch-all.
with the RIS, it's more of what interventions are they looking at? What services are they providing to?
Okay. Makes sense.
And the goal and all of that always is to have the human being succeed when they're back out in the community and deal with whatever, I call them demons, whatever demons haunt
Yeah.
them. So the focus is to rehabilitatively get them there, therapeutically, I guess.
Anything else on programming?
Clear.
Just a quick update.
Condition work since our last meeting, so when we had Richard here, last one, one of the things we spent some time on was taking a look at our conditions that we imposed, and as I'm sure most of you remember, there were some discussions around a few of the special conditions, how we were applying them, what they said specifically. So based on his assignment for us before he comes back again, the first was to look at the violation guidance, which MJ's talked about. So I asked Lynn and Pat to work with me on coming up with some initial thoughts on our special conditions, particularly the ones that Richard identified as problematic, to look at how we might want to consider changing those. And after we met with that, MJ had a couple of other suggestions, which we're going to work on as well. But hopefully everybody had a chance to look at the memo, and I can quickly go through what we looked at, what we identified as sort of our first look at how we're going to change things or potentially change things. The first one dealt with the curfew. And so our revision for that would be, again, one of the things that Richard spent time on was you need to have some kind of a timeline set up for people that are going to be have this condition imposed on them, so it's not wide open for the rest of the time they're supervised. So we came up with a revised condition 10 that says you shall abide by a curfew for the first 30 days of supervision if your parole officer deems it necessary. So it's not required that they be on a curfew, But if their parole officer deems it's necessary, then they would be if we impose that condition. And we gave a brief explanation of our application of this, which is that it establishes a short-term behavior change and becomes a benefit eliminated if they're doing well. We also talked about the extension through the condition modification process. If the PO, for example, finds at the end of 30 days that curfew is a problem for this individual, they can request an modification to continue with the curfew with justification. The next one, yeah, go ahead.
Take these
Yeah.
condition by condition, or do you
Sure.
want to go through your whole memo?
No, but let's do them by one at a time.
I guess I struggle with this one and a later one around the 30 days. I understand where you're headed with this.
Right.
And I understand the conversation with Richard. I just am also looking at it as administrative portion. So if after 30 days, so abide by condition, by a curfew for the first 30 days. So after 30 days, is that condition staying on their parole agreement? Are we issuing an amended parole agreement? Also, what is,
Well, the
I
30
think
days,
also what is the deems necessary too? Are we gonna look at application, are we gonna look at providing some guidance of what deems necessary
No,
to give it?
that's the PO's job.
That's his
This is
discretion.
the PO, even if you have this condition the way it's stated, they only put GPS, I mean, a curfew or GPS for that matter, because I know that's coming down the pike for 30 days. If the person respect to what you're saying, MJ, if 180 days down the road, the guy or person starts misbehaving, the PO can then put another 30 days, put the GPS or the curfew back for another 30 days. Based on what Richard told us, that this is too floppy, that it needs to have a little bit more structure. He suggested 180 days. We put 30 days because that's what the DOC already does. If we're not, then
Well, they
also-
have to. You can't track somebody for more than 30 days without reviewing it.
Okay, so
That's,
then
that's unlawful.
add to that, the fact that we're gonna possibly change the condition modification methodology of where the PO can just email us and we can change it. They don't have to come in front of us. Then that makes it a lot more like the way it is for the way the condition's written. So this way we tighten it up and we make it for 30 days. If they don't misbehave in that 30 days, it's gone. Less conditions. So what is it that makes
It doesn't
happy?
say that. It doesn't say that.
No, it doesn't.
It doesn't say that. It just says first 30 days.
Yeah.
You have to abide if they deem it necessary, but then saying may ask for an extension if warranted. But nowhere it says on that condition that it leaves at the end of 30 days if, no matter what happens.
But it doesn't say any different. It says for 30 days.
So what was the problem with saying you shall abide by a curfew if your parole officer deems it necessary?
So here's the issue. Please, let me try to explain this. We've spent a lot of time with Richard Stroker, who is one of the foremost experts in the country on a lot of different things with parole supervision. And imposing conditions has been a huge reason that many people don't succeed. And so from his documentation, experience, and science, it's pretty clear that short-term behavior change is the goal for someone to be successful. He also had documentation that if they don't follow through with that, having that condition on is not going to change them one way or the other. They're going to still end up in our bailiwick. So the goal is to provide the opportunity to use a curfew and electronic monitoring in that first short period of time, where they would understand that after 30 days, if they're doing well, this goes away. They don't have to worry about it. It becomes a benefit, a reason to continue to be successful. If something happens where it's needed again, we can address that. But at the beginning, the offender knows that at the end of 30 days, that condition does not apply. You wonder, when does that begin? When they sign the parole agreement, period. That's the idea behind it.
Because the wording, the way it stands now, says you shall abide by curfew if your parole officer or the parole board has cause to put you on one. That's just super clunky. We don't run around and put curfews on people.
Well, by statute, that the statutory language says you guys are in control of that term.
Right,
Correct.
right.
That's why it says that.
That's super.
Yeah, well, then talk to the legislature, because they wrote the law.
I'll tackle that.
I'm just saying, I think that's where really your energy would be best spent. Yeah,
I guess, speaking from the administrative side of things,
Sure.
there's a lot of administrative stuff going on here. I'm just trying to figure out, one is also, I feel like we've already got a nest stirred with DOC that adding these 30-day requirements, like with we're not giving electronics or curfew all the time when they're requesting them. By now limited it even more. I think it's gonna, I'm just being devil's advocate. I
Okay,
think.
well, let's be proactive then. Since we've had the discussion on electronic monitoring, when they request it, they get it. That's not an issue.
No, not always.
Well, I have not denied any electronic monitoring.
I haven't either.
Since we've had that discussion. So
I'm gonna stop. I'll just stop.
the important thing is, if this condition is applied, how do we make it so that it works for both sides?
well, if I was arguing on the PRO side for the offender in this situation, I would say you need to articulate that it expires.
Yeah.
Absent a modification request. That needs to be clear.
Yeah.
That would also help you with your administrative piece, because you don't have to change your condition. And if I asked you for the current parole agreement, it would be very clear to me that we're past 30 days.
Right.
Yeah.
And that doesn't apply anymore. So I think as
agree.
far as that
So
goes.
a statement that it automatically expires, written right into it.
After the
That's what it
30
says.
days.
It's 30
Unless
days.
you want to do modification later.
Yeah.
And the
But
30
but
days,
30 days, they mind their P's and Q's. Day 180, they start not showing up and messing around. If you don't get this right, then there's going to be no authority of the DOC to then impose it.
To put it back on.
Absent coming to you and having a whole debate on that, but that's.
They'd have to come back
So-
and put in for another modification at that point.
and the philosophy too, again, is coming back to the idea that if we want folks to be successful, we have to be cognizant of not over conditioning people. And continuously putting in the what ifs. What if this happens? We gotta have a condition for it. And
Well, I mean, again, I find that rich, considering I've asked about several times
Yeah.
to get condition 16 off your radar, and I
yeah,
keep getting told to go away. So, over conditioning, I think there's one right there that
Oh,
you guys can
absolutely.
address easily. But
Yes.
have you guys talked to DOC about this and what the
No, not
30
yet.
days looks like?
we're talking to the board first.
I don't know what their
I
response is.
intend
That's a short window
And
of
this-
time
Yeah.
to do a lot of things.
And this goes back to me also advocating that there's some kind of, I don't want to use the word application because I think that gets how the board is choosing, how the board determines what conditions to apply a case, like general, maybe not what, that's why I included the condition guidance document,
Mhm.
is I think that's too much. And it's also DOC helped draft that. I think it's more of what factors are you using to apply, to give this person a condition, and kind of really putting that into policy around, I'm going to get, alcohol condition is given based on a DUI history, based on alcohol use during commission of the crime, so forth. It just kind of, it doesn't have to be long, elaborate, but just some kind of method to show, okay, I'm going to give a curfew for the first 30 days because of the track history. They have in really looking at expanding more of how you're using these conditions too, and how you're setting the conditions, I think is more important. To me, is more important than what the actual conditions read. So it's clear to everybody, including the individual under supervision, why they have this condition.
I totally get
Great.
incentivizing them
Yeah,
to eliminate them. If you do X, Y, and Z if you're successful in that, then we're gonna eliminate one of the rules. That
Yeah.
is motivating. It should be
It should
motivating.
be, exactly.
Yeah.
I
Yeah.
think that's something we don't, and maybe also looking at, we have so many individuals on parole that they're on this set of conditions forever. Some of them can do it, some of them can't, but there is now incentivization. It's just that they get to call into the.
For example, when we get someone who's been on community supervision for a year, and during that year's time, they've been on GPS and curfew. So they've been in the community, they've had this condition under their furlough supervision. We're putting them on parole. We need to have a condition for curfew and electronic monitoring after they've been in the community for a year. Most likely not.
No, and we've had the opportunity through the condition updates through changing our parole agreement to look at some of those conditions, but that's really the only mechanism
But it's
that
not
is their parole
unusual.
agreements ever looked at.
It's not unusual to have the PO requesting. We ask why.
Yeah, we don't get a lot of, and we don't get a lot of condition modification requests.
Yeah, they're not gonna go looking for more words.
The purpose initially here is for us to have this discussion and see where direction we want to go.
And I think it also is around the condition modification process too. I would want to have an in-depth conversation about that as well, whenever the time is right, because I have lots of thoughts.
Okay. Shall we go on to the next? Condition 11, Richard had mentioned last month at our meeting that, what does this mean? He thought it was very confusing and difficult to manage. And there are other conditions, including special conditions for domestic violence and sex offenders. And obviously our special condition number 18, which can be anything specific that we impose, can address that particular issue of restricting who they have communication with while they're on supervision. Since we wrote this memo and talked briefly with MJ, one of the things we looked at too was the domestic violence and sex offender conditions. And in both the sex offender and domestic violence condition, the first one is that the person cannot have communication or contact with their victim. And it explains the different contexts for that without having written approval from their PO. And we thought about, and this is another one that we'll be working on, putting this in place of 11, that there be a condition that the offender not have contact with their victim, using that language. It's in both the domestic violence conditions and the sex offender conditions. Take those out of that and just have this one condition, so that if it applies to someone who is not a sex offender or a domestic violence offender, but we want to have restricted contact with a victim from another type of case, we've got a specific condition that addresses that. So we would eliminate the 14A and 15A and have just special condition 11.
I've seen that creep up more with assault cases,
Right.
families of murders and so
Right.
forth. It's been creeping up more.
Well, there's a difference too between victims of crimes and association with individuals who are going to lead you down a path where you are going to reoffend.
Right.
So the restriction that you don't hang out with people that have felony convictions, when an individual behaves very well, absent hanging out with their buddies who have felony convictions, that's the associate condition. But don't know how much teeth it has at the end of the day anyway, but.
Anything else on that one? 12 is shall take forward of the restitution and plan agreed upon with your parole officer and the state restitution unit. This was your idea.
So- When you looked at this condition, did you look at the language in the parole guidance document, or did you look at the current language that we amended with the restitution unit earlier this year?
We didn't look at either.
Okay, because our current condition says you shall pay court-ordered restitution to the Vermont Restitution Unit in a plan agreed upon with their office and to the satisfaction of your parole officer. And we worked with the restitution unit to create that, so.
Sounds pretty clear.
That's what I thought.
What we were looking at did not have that in it.
Okay. I'm assuming it was probably an older
So that's taken care of.
form.
13, which is very similar to 10, the revision says you shall permit the use of electronic monitoring devices as directed by your parole officer for the first 30 days of parole supervision and abide by the Department of Corrections rules regarding its use. So same philosophy here. For short-term behavior change, the use of electronic monitoring, if it's needed beyond that.
But so just as a question, Lori, would it be better if that said 180 days, or you're saying it shouldn't have a limitation on the days at all?
I'm saying the latter, that it shouldn't have because if I'm defending this individual and in the 6-month mark, this is expired at this point. 30 days been up, they were successful, it's gone. 6 months later, DOC says, oh, they're misbehaving, we need to put the bracelet on again. I don't see that they can come back and do that. That's not an extension. That would be an additional modification. And then that would require arguably a due process style hearing. So if you front load it with a limitation like that, I would just ask you to consider what's the consequence when something surfaces 6, 8, 10, 12 months down the road. Are they able to come back?
Why wouldn't he just bring them before the board as a reprimand? And we could apply that condition again.
Because you're outside of the first 30 days.
No. If he's,
How it's written.
if this behavior in the community is 180 days out, that
Yeah.
he's continually eloping, he brings it as a violation for a reprimand. That
As this
is
is,
misbehavior, not a violation of
But
the.
you're saying not to add this.
well, I'm just saying that the way these conditions are currently written, it's within the first of something. I come back 6 months from now on a reprimand and
Yeah.
I would argue you can't now add back in. this condition.
Within the,
It would have to
that
be-
makes
Okay.
sense.
No, not as a violation, but we can add
No,
that
it's
as
the
a
wording.
sanction to the reprimand.
I think the wording,
Before the first.
I agree you can do that, but not how this is worded,
Yes.
is what I'm saying. I agree you
So-
can do that, but if you limit it, if you say you can only
for the
use
first-
this in the first 30 days, you can't use it in 180 days. So,
All right, so,
And-
so
You can only use
Yeah,
it, so it's the
also
wording.
saying from an administrative, if we're trying to automate stuff, we're trying to do things, having conditions that can go on and off with day marks in them is gonna be really hard to do.
Well,
So
then what's the difference between 30 days and 180?
I'm saying take the day, if it were me, I wouldn't even have a day in it, and in your guidance, put out some kind of guidance that this is how you want the condition used.
so I'm gonna come back to our training again. We're getting away from that.
I'm not getting,
Yeah, we are.
well,
I'm
if you're
not
trying to
getting away from
motivate
your
somebody to be
training.
successful at the beginning, just
And-
know you can't do what Wayne just suggested 6 months
Exactly.
in. Just
And-
know you can't do that. That's all.
I understand that.
Okay.
And I come back to, it's the short-term behavior change that we're looking for when we put somebody on parole that have ultimate good success, long range. And the other thing that struck me too, when we were talking with Richard, the science shows that having them on GPS or a curfew does not reduce their risk to violate.
Unless it's monitored 24 hours a day.
Which is not.
Which we.
And so the
everybody
other
knows.
areas that are more important, which are the condition 1 violations and things like that.
Yeah, no, I fully
More
understand.
important.
I'm just trying to caution you that the way
Yeah.
it's written, you can't come
No,
back
it would have to
after
be
the
a-
fact. If I understand your motivation,
Yeah.
for sure.
So I have a question then, is, say they come back for a reprimand or a violation hearing, and the board wants to impose it again, how do we impose it again when it says for the first 30 days of
Well,
your
it
parole
has to be
supervision?
I would just put something on here that indicates that
Doesn't have to say for the
You
first.
could go to
If
special
you say-
condition 18 and write up a draft of what you wanted.
Yeah, but just
specifically.
get rid of for the first.
well, again, even if you want to keep for the first and for however many days you decide, if you put
I
in
think
this
before the first.
I would even put this condition will expire at the end of that term, with successful completion of that term, and only subject to but may be requested in a modification, you know, without restriction. I mean, we could word this so that you have the ability to put it on later, I guess is what I'm saying. Very poorly.
No, which I like that idea of rewording it so it has an
Put
option.
it back on.
Yeah,
That's
you just
important.
need something in there that allows it to come back. So you keep your motivation for the first 30 days,
Yeah.
but let them know this is great, continue down the road. But if you're brought back on a violation, you reserve the right to impose this condition for an additional 30 days, something like that. Because then that way that triggers DOC to do their thing again too, because I'm just concerned if we don't give you guys that ability to trigger it again and it just falls off the agreement, it's changing the lay of the land as to their rights.
I like that. It would address some of the administrative issues I was.
Well, then you don't have, you know, it itself executes absent you seeing a or a violation in the file where it was reimposed. You know what I mean? Like, cause then you're going to have new stuff anyway, but then you guys don't have to worry about whether it's peeled off or not, or doing math on the calendar or anything like that. Administratively, that would be a nightmare. Yeah. But I think that would preserve, Dean, your desire to give them a reward
An
for
incentive
good
to be
behavior,
good.
for sure.
Right.
The goal is not to see them again.
Yeah, of course, of course.
Okay, so we would do that for 10 as well, same type of
10,
language.
13.
16, we took out the issue of work being approved, as it also is addressed in other parts of parole conditions, and simply stated the resident shall be approved by your parole officer.
I struggled with this. I will just put it, I struggled with this one too, because it seems too simplistic to me that yes, it should, your resident should be approved. Well, but also to me, if I was a parolee, it's like, okay, my residence was approved, but it doesn't say anything about any changes need to be approved, which I kind of like the language in the other one that if you can't change your residence without prior approval of your parole officer. And I know changes are in condition 3 or 4. I can't remember which one it is anymore.
Notification.
Notification, but not approval. So I don't know. I just not having that change your residence piece in there. I don't know.
So
I'm just trying to be obvious to a parolee what their expectation is.
if he couch surfs or changes his residence on his own and is not caught by his diligent PO, Ollie Humphrey, if he's caught, then he comes back for a violation because he violated that.
Right, but I'm just saying. I just
Yeah,
don't
it's
know,
simple.
I don't know if the changes are. So that's why I was saying it was my thought, but
Lord,
so I was just thinking, what was the current language? Just kind of look at. Hold on.
Or you want to get rid of.
You shall reside only where approved by your parole officer, and you shall not establish or change your residence without prior approval of your parole officer. It's just basically taking work out of the current condition. Because I know work isn't usually
yeah,
an issue.
Oh.
But I don't know.
It's good. It's good. Just go.
and part of the goal too was to make it simple. One of my concerns, and I'm sure Pat has this too, and your review conditions when we started doing this, was to make sure that they understood everything. And a lot of times, I'm not sure they do.
No, I totally get it. I think that we use it's something we do across the board everywhere is we use a lot of big words and fancy terms to try to meet all the requirements of statute and legalese and everything, and that a lot of these folks don't understand, and I totally get it.
But Lori, did you say that from the department, they want this one to go away?
No, I say the same thing to the department. I say to you guys, this is a nightmare in the
Yeah.
judiciary. It's a housing shortage. There's no place to put people that have jobs and are functioning. Nonetheless, people that are somehow,
And that's been helpful, your work with them, because I'm seeing a lot more willingness to look at another option that they wouldn't otherwise consider.
yeah, I mean, I want you to know, I mean, I do go back, I had a recent case where the mom's house kept being denied, primarily because there was a car there that wasn't operable and it was more rural and the individual wouldn't have success in meeting their appointments was the excuse. But by all accounts, it was a safe place to be. Mom and stepdad were not a problem. And I'm just like, why are we holding this individual? This doesn't make sense to me. And it's this constant, why are we getting so hung up on where they lay their head at night, as long as we know it's like, obviously with sex offenders, we can't have them hanging out in schools and playgrounds. But I'm just saying that this to me has become, at the time when housing was at a premium and there were many options, it would make more sense. But the judges hate this one. It's a nightmare to defend for both you guys and DOC. And I just wish we could creatively figure out a way to, and I know it's a tough struggle. But so sometimes then I'll come back and be like, can we get rid of 16? I've got an appeal right now against you guys in relation to 16. Individual was released on parole with condition 16. Contested the condition 16. I filed as moot because the individual was out. Can't give them the relief anyway. They're out on the contract. And the judge said, that condition's going to follow them. I'm going to put this for merits. So we're going to have a hearing on that condition. The individual has since been rearrested and is now incarcerated. So I'm filing my motion again. But just, so he kind of helped me out there. But, the judge was just like, look, if this condition follows them, he still has the ability to challenge it in appellate review. Okay. So that might, if I don't get it dismissed as moot because he got rearrested, that I might get you guys some guidance on that as well. Out of the judiciary anyway.
And this is one condition that I see where it'd be helpful for the board to establish when to use a condition. Because I see it very heavily used for those that are incarcerated. And it's tagged on to, if I looked, probably a good chunk of those that are incarcerated coming up before the board are getting condition 16.
Absolutely.
And is it always necessary? I don't know. I don't know the right answer, but I think it's a good conversation to tackle as a group of how do we want to apply 16? Because
and I would ask that question of DOC when they're in front of you. Why are you, if they've had previous experience, why did you guys use 16? The answer may be it's a product of their sentence. Some sentences require certain restrictions. Others, they may say it was their determination based on, and then you guys can take that or leave it. But I think that's a question to ask as to why DOC or would suggest that you guys impose that. Explain to us what advantage that there is in this situation.
A lot of times they're waiting for transitional housing to open up, which is months.
Oh, it's horrible. The waiting lists are horrible.
So
Or they do want to live with mom, but mom's where they did all the using and the criminal activity. And
exactly. Yeah, exactly. And so, I mean, and it, we are at least getting bed ranking numbers now out of these agencies. So we have an idea, okay, they're on 10th on the list. That should be sooner, so there is some, movement there, but it just, housing is at a premium, period. And so if there's a creative way to address a situation without using that condition, I encourage you to look for it. That's all. Because that shouldn't be an impediment to an individual. So, again, I'm not marching either side of the argument on that. But it seems to me if the only thing holding an individual up from getting out and trying to be now successful is where they lay their head at night, and couch surfing is the only thing available. If their other risk factors don't present, I think it's worth not using a 16. But
and
we agree.
And I know sometimes we're taking it off 2 months, 4 months down the road after this individual hasn't got housing, because we are doing 60-day reviews. I'd also look at some of that too, maybe in the initials of, maybe we look at some of those cases as a group too of, we took it off 4 months down the road, but maybe we look at it and go, well, why did we put it on? And maybe we do some of those reviews as a group at staff meeting. Because there must be a reason why we took it off. So why did we give it initially, kind of thing? Because yes, almost everybody's on some kind of wait list somewhere.
Yeah.
And do they need to be on a wait list somewhere always?
But if you do Joe Q Public, and I remember when I was working in the facility, and like, for example, somebody sobered up, you had to release them. And the guy comes from Bennington, he's, headed to pajamas with no money. I didn't release him until I found a way to get him out. We parole somebody who has no place to go. And he's on the street, and people say, well, is that a nice parole board? We paroled Tom Giffen, and he's living on the street on the corner panhandling. Is that helping society? I mean, that's what the public is gonna see. I understand what everybody's saying, but if you're gonna throw somebody out with no housing, maybe counselor, maybe can find some place in the local shelter. I don't know if that's something that,
Well, I'll just tell you that homelessness is not a
Right.
bar to a lot of services the state of Vermont offers.
Yep.
And a lot of my other teams defend decisions where the agency won't give housing resources or money because they haven't qualified in other ways, and that the homeless people are just all over that.
Mm-hmm.
So, there's a narrative on the other end too, just
Yeah,
to,
well,
just to
absolutely.
consider.
It's something too, we gotta be careful of.
Yeah.
Because, and I appreciate the work you're doing on that with DOC, but if we start overturning all of these condition 16 requests, we're gonna be dealing with the same thing that we are with the interrupts.
Well, my question on that is there are programs available to the state for people to get hotel vouchers for a limited
Yeah.
period of time.
Well, that's what's
And,
coming
you
in
know,
with prisons rights office.
And all of that stuff that's, there's no thought about that kind of thing to help these people, which is going to be their ultimate impediment when they get out anyway, right?
And I think there's also individuals that I think come before the board and say, I can't make the phone calls I need to. I could get out and go to the homeless shelter and try to find myself a place to live, but I can't actively search for one. But, and I think in some cases, those are still the ones that are getting 16s because they're on a waiting list somewhere.
And we're working on that too. The caseworker, I have to prove in front of the courts that the caseworkers have put in, reasonable effort to help these people.
Yeah.
And they are, as a whole, pretty diligent about helping. So just be cautioned when they say that they haven't had the chance. They have probably proposed 3 or 4 different places that got denied, and no one, Uncle Jim that will give them the residence can't get on the phone. So.
Right, yeah.
But yeah, it's just one I just ask you to be particularly sensitive to, because the judges are just all over it in relation to holding people back because of homelessness.
Yeah.
So I'm just the messenger.
We get it. Yeah.
So I'm gonna skip out to anything else that you guys need.
Thank you very
Thank
much.
you, Lori.
Pleasure to have met you.
Nice to meet you.
Reach out if you guys need anything, and then I'll be in touch with Dean and MJ and any help you need on rewriting those.
Great. Thank you.
And I'll get the information that you all requested, and I'll send that case over. Okay?
Thank you.
All right, you guys. Thank you. Have a good day.
You too.
too.
Thanks, Lori.
Quickly finish up. The other thing that we're looking at was completely eliminating 14, the special conditions for domestic violence. If we remove A and make that another condition, 11, no contact. B, I believe, is that the programming one? And we have that condition covered in special condition 7.
Yeah.
And the last one is following any relief from abuse orders, which really is the same as condition 1. Punishable by law, including violating court orders or relief from abuse orders. So that would eliminate 14 altogether and come up with a new 11. 12, we agreed, doesn't have to be changed. So we'll work on some language difference for 10 and 13 and 16.
Do we want to change condition 1 if we're getting just to be more specific around relief from abuse orders? Say including violating any, I know it says court orders, relief from
Yeah.
abuse order is a court order. I just don't know if we're looking at simplicity, if we're looking at more simplicity for understanding, would folks understand that, or would everybody understand? I know you're looking at me crazy, Dwayne.
Well, I mean, I don't disagree with you, but I'd make the argument either way.
No, that's where I'm sitting, because that's why I
So you want to
advocated.
commit any act that would be a violation of law, include violation of temporary restraining orders, or?
I mean, 'cause it's a crime in and
It's
of
redundant.
itself.
Yeah.
Yeah. Because we have so many surveyed on it. So I don't know. I just, because I was the one that advocated for 14s to go.
Well, I think a very simple change is all court orders, period. That's fine.
Violation.
Those is including any
Yep.
court orders. I don't think we need to change.
Violation of condition.
I don't think, I just,
Are there any other special conditions that you wanted us to look at? Okay, so we will reconvene and finish up another revision.
Mhm.
You want to cover the memo and suggestions, MJ?
yeah, so the first thing I ran this by Dean is I really expanded the policy in our manual. Because I felt like if we're gonna really ground the training that the board's been provided from Richard, I took a lot of the language out of his 2019 PowerPoint. And really going into how, like I added I don't have them side by side. It's a little bit, I don't have the paper packet in front of me. Lord, no, it's all good. I'll borrow this one. But really added like around that you're imposing conditions that address risks and criminogenic needs, but also imposing conditions, understanding that the first few months of supervision are critical for successful outcomes. I really thought that should be grounded in policy, if that's how we're going to impose conditions.
Absolutely.
And also, I took the 4 bullet points right from one of Richard's PowerPoints around the board imposes conditions for the following reasons: define boundaries of acceptable behavior, require actions that might aid rehabilitation, require restitution if the original sentence orders it, establish critical reentry and transition objectives. I thought that was, I really looked at that PowerPoint, and I'd be willing, I can send that PowerPoint to any of you if you don't have it.
I think Katie and Sam are probably the only two, unless they got.
I sent it to you. I'll send it to you anyway. And then the other suggestion that I had, and I've already kind of posed it, is really looking at putting some bullet points under every special condition of around kind of your thoughts about how you're imposing this condition. What, not necessarily that detailed reference, that the detailed condition guidance document, but more around what are you looking at when you're applying this condition? What kind of factors? So then it's clear of whether it be, I mean, alcohol is pretty clear, drugs is pretty clear, but like with curfew or electronic monitoring, is there like a absconding history, or this person has a history of going out in the middle of the night and buying drugs? That it just kind of, and I was going to take a stab at it, but I didn't have time, but just putting like some little factors to make it clear to POs and to supervise individual parolees, this is why I gave you this condition, kind of thing. Or what these are the factors I'm looking at specific for this condition. And it doesn't have to be a big, huge, extensive list, but really, then it allows anybody who's setting conditions to know, okay, this is how we're doing it. Because I know there's a lot of questions. Tom, you pose a lot of questions of when to go against the parole officer, when not to go against parole officer, that kind of thing. So, and then it's not quite as, it's more clear and provides a little bit of transparency and can also lead to consistency. So that's just kind of what I was thinking of, not doing it today at the meeting, but more as a stab down the road, kind of as we're expanding this chapter,
That's a good place for it.
and just put it in the manual and not have anything separate.
Yeah.
So that's kind of what
It's gonna be a long chapter.
And I don't think there's anything wrong with it. I mean, how long is it right now? It's not that long.
Chapter 11.
Yeah, I mean, it's 5 pages. I mean, and I don't think it needs to be, this condition guidance document, I'm gonna say, I think is a little overkill. But I think it goes into a lot more for each condition, where I think we could just look at for programming. And right now it says the condition applies to offenders who are mandated or referred to risk reducing treatment programs or counseling based on validated risk assessments and offender classification. I think adding that line, and I don't think you're going to add a huge amount to the chapter if we just add in some factors. I just think it might, if we can come consensus, if we want, I don't know, just my thoughts.
Get to that chapter. We'll do that one first. Or
I would say if you're going to look at changing conditions, we should do this chapter for one of the first ones. But I think it also would be good to put some of this in and have Richard look at it as well as part of that. Maybe as the condition work groups meeting, really have that question of, okay, I apply this condition now. Well, no, I apply it in these circumstances, and really look at when you're applying them. Just some thoughts.
good.
So that's kind of the gist of what I had on that. And also not trying, I think it's also, we need to look at the condition modification process too. I don't necessarily want to go through that today, but I don't know if the work group at all talked about that.
Well, the only thing we talked about is how can we develop a less difficult process where we have to wait a month? And can it be an administrative hearing? And if so, how would that go? If
Yeah.
it needs to be a regular hearing, is there any reason it couldn't be scheduled at the next day when there's a hearing? So that basically 3 weeks a month, there's opportunities to modify conditions regardless of where you're from.
Right, and I think those are some good that's a good conversation to have, is how do we want to have that process look? Because one of the biggest gripes is I have to wait a month to give this condition
Right,
in order to
right,
respond to the
exactly.
behavior that's going on.
We don't want to do that.
Right,
Totally.
so.
Yeah.
I think that would be.
Okay.
Maybe that chapter, I think condition mods is a chapter in and of itself. Maybe looking at that chapter at the same time.
Got a lot of work. What's your decision making?
Yes.
Ready to go?
Yeah. Hold on just a second. I wanted to look at the manual for a quick second.
Talked to Samantha lately?
Yes, I have. I just talked to her yesterday.
She didn't.
She's doing well. She was actually in a joint staff meeting, but she had a medical appointment this morning. I was like, are you crazy? You don't have to join staff meeting. I am gonna give you her availability during the schedule part.
Okay.
So I think it may be modifying conditions of parole as part of the parole agreement
Mhm.
portion. So I'm wondering if we might want to look at the parole agreement portion as well.
What chapter is that?
Well, and the question I guess would be is modifying conditions of parole, does that affect, should that be in the parole agreement section or should it be in the setting conditions section of the manual too? I would almost advocate that it probably fits better in setting conditions.
Mhm. Okay.
Let's see enough. I gave kind of a quick update on the parole summary. We're going to start seeing it more and more. I will give you an update when the one in the offender management system goes live. And I will give you an example because it's going to look different. And the reason I say it's going to look different is it's not going to have the embedded, it's going to be a PDF file, but it's not going to have embedded documents. So if it's, the affidavits are going to be at the end, the case staffings might be at the end, that kind of thing. So we'll, once it's final, I will send it out. And we'll also make sure it's on the July agenda to talk about, because it should be coming up live in our system pretty soon. So I haven't got there yet, but I've got to email them and find out an update. So I passed out guidance last month, kind of on the fly. Was that helpful for folks? That document, kind of
Yep.
putting everything,
Yep.
all of our decisions in one place. How's it going? Kind of skipped over that. Everybody's quiet.
Going fine.
I
Well,
know.
Looking at the data, it's not going so far.
And I know one gripe that came up was how we're assigning SCMF to cases. I think it was you, Wayne, that brought it up.
Well, I just happened to notice that whoever picked the cases to do didn't pick the ones that are on the new form. I'm looking at the new forms going, wow, I could have been done with this 10 minutes ago.
So is your suggestion for Colby and Carla when they're assigning to maybe look to
Yes.
see which ones are on the new parole summary versus
Yep.
just randomly picking people off
Oh,
the
it's
list?
all just random.
He understood that it was random when I said, but I think that was one request, if possible, if when you're assigning, just to look to see which parole summary it's on. So then the difference in coding, let me pull it up. I didn't think it was bad. I didn't think it was that bad.
It's improved a lot.
Well, we've had better months.
Yeah, we've had a lot worse months too.
I do have a couple cases that we can do a full review on. So this is 2 months. This is May and most of June. It's not all of June, but it's most of June. Programming seems to come up quite a bit. This month I didn't find a trend necessarily where I have in previous months of like certain like previous months it's been like one domain, where this month it seems like it's a more scattered all over the place this time, and it's not necessarily one domain. So it's kind of hard to find more of a trend. One of the cases might have been just a box issue. It's on page 2 of the thing, where Pat, you had both aggravating and mitigating checked off, so that might have been just
Yeah, I evidently,
forgot to uncheck one
Yes.
of them.
yeah, And by the looks of it, I should have been aggravating. But I don't know, I'd have to go
Maybe,
back, but
you're right, but it's just. So do you want me to play some audios and look at the 2 cases that I have in the, if I can do that?
You guys,
I don't know that we need to. We've got the cases
Okay.
written out.
I have a question about criminal parole history. How in the hell can it be mitigated on any of these? I don't understand.
No, that actually makes me, I missed one. I forgot to highlight one red. We did
Because
have an aggravating
they're
and
In
mitigating.
jail or they're on
Okay,
parole
so
and
who-
they've done something criminal. How is any of that ever
I
mitigated?
think it can be mitigating if it's their first time with history. So if it's
Yes.
their first crime committed
Ever.
Right.
ever.
And there's
it
nothing
can be
happening.
mitigated.
Nothing
If
is
there's no
mitigating.
I've never
history.
gotten that type of person.
Get a sex offender.
no, you won't get
I
it.
think by 10 or 11 years. No,
It's very-
two people, that was
You
their
may
only
start to
crime.
get some.
No, we had a
yeah.
sex offender that, that's the only crime he ever did was a sex offender, the only one.
It says no prior criminal history.
Oh, that guy that's
And we had the.
out of state that was
Had the
crying about never
embezzler.
getting out.
Yep.
Yeah.
I'm never gonna get out.
She
We
was
never had a-
absolutely clean.
Yeah.
Other than that.
There's a few.
Still aggravating.
Doesn't happen much. It wouldn't be aggravating, though. It's aggravating to us, but
But there is.
I'm
some-
gonna start doing 2 boxes.
But you know what's interesting? If I had caught this, it would have been interesting to look at the case where we had, so it's HV on the last page, where Tom put mitigating for criminal and parole history and Pat put aggravating. So it would be interesting to look at that case just to
where
see.
are we?
Oh, the yes on the.
The last page of the
June?
worksheet,
June.
June, Chittenden, HV.
Oh, okay.
It's just interesting how I missed that one. I didn't highlight it red.
It was so aggravating and mitigating and criminal. history.
Hmm.
Oh, yeah, and then we've got another one too.
And
Yep. Tom likes to do mitigating. Others like to,
Before you were saying it was always aggravating, so I'm mellowing.
Oh, yeah.
Like you versed it on a different one.
Where a guy says, so
It's a crime.
the other thing is when somebody says, I'm gonna go back to using heroin once I'm off supervision.
Yeah, that guy.
I don't, I cannot believe
I know, I was like,
that has gotta be aggravating. I'm just,
It was to us.
Yeah.
Yeah.
In the very last one with, Dean, Lynn, and Tom,
Very good, at least do a bit of safety
Dean
training.
had
So-
neutral and the other two
Sponsored by
had
the state.
aggravating
Come on, Tom.
for criminal history.
I think neutral is a little bit. Okay, let me pull it.
Neutral.
Yeah, I think neutral's a little dip. Okay.
Multiple minor crimes, long intervals
Yeah.
between them.
Yeah.
Minor infractions with no escalation on
Yeah.
one individual. So I think it's really how you're looking at criminal history. Too.
Right.
And looking at. Yeah,
Which one did you want to go over?
I had, so
Kevin Estee?
I have Kevin Estee in the folder, which is,
yep. That's one.
I believe that's Dean, Tom, and Lynn.
Mhm, mhm.
And there was a difference in programming
Yeah,
where Dean had neutral, Tom had aggravating, and Lynn had mitigating.
I think I would have put it back to mitigate. I think I probably did it ahead of time, and then I think in the hearing, he said he's doing IRP, so I probably would have put mitigating.
Yeah, and without listening to the hearing.
Yeah,
we
I'm
would
sure
not
that's
get the
why.
information.
I'm sure I did it ahead of time and then click it. That's my mistake on this one. I can see how I wrote it and. But
We gotta learn to unclick.
no, I just.
No,
I know,
I've
I
gotta
know.
learn to unclick.
Talking about,
Pretty much
Kevin
had the same
Estee.
comment.
Yeah, I just, what I did was I
Yeah,
could have
things
changed
he
it.
didn't change his,
I did it ahead of time and then I
Yeah.
saw that I wrote in, he was doing IRP and I didn't, before it was, he was not required to do anything in the facility. And that's
Yeah.
all we had and nothing else. And then they said later on he was doing IRP, so. I should have just checked it, come back and checked it.
So one of the comments I was gonna make, see if you think this is an appropriate place, whenever there's restitution,
Yeah,
put it under case specific factor. Just note it.
Oh,
Okay.
I never thought about doing that.
I mean, I don't think I mean,
I know.
is it a decisional factor?
No,
I think it could be a no. I mean, I wouldn't necessarily score it as a case specific factor, but
it's
it could
just
be a no.
related to the instant offense.
Yeah, I just don't know if it's,
I don't know where else to put it. That's all.
I don't know if it's do you
It's just like
decide,
Information.
yeah, do you make your decision based on restitution?
No,
So I don't know if it's
but I
applied
want
to
to
the
know that they owe
SDMF.
restitution.
Okay. I mean, it's in the parole summary.
Yep.
It's in the parole paperwork. I don't know if it really needs, I don't know, I wouldn't say it needs to go on the SDMF, but
But there's no problem if I put it there, then just.
Yeah.
So,
I just wouldn't score it as case
Well,
specific.
it's scored the same as you'd score it without it. Or neutral.
Still
Right.
neutral, still neutral, yeah.
Yeah. I mean, case specific factors, I think is a hard one, is
It is.
I don't think it's not one that gets used very often, because it has to be really something out of the norm that's gonna weigh heavily against or heavily in favor of paroling someone, and I think,
Is there anything else in SD we wanted to?
I think that was the only one in SD.
That was out of sync.
Then Mayville. Mayville was ability to control behavior. I believe.
Well,
Let's see, aggravating.
Wayne and I had,
Aggravating and
Aggravating.
mitigating.
Yeah, I was feeling really mitigating last go around. I was like, filling that out more than I ever have at all. It's like, I don't know.
And Tom too. Tom said he's been filling it out
Tom
more
and
than
I-
everybody.
I'm mellowing it. I'm mellowing.
We have compassion.
I always have compassion, but
Finally getting through it.
yeah. Brutal, you
You're
guys,
gonna need
brutal.
counseling after this.
I probably don't need
Can't
it.
be that nice. What was wrong with this guy again? I gotta read it.
So I wonder if and that's where sometimes the audio.
Which one was it?
Mayville,
No, what was the?
Domain.
Fender,
ability
To
to
control
control behavior. Tom and I,
You remember that
Or
the guy who
Wayne-
did all the programming known to man? He'd taken like 36 classes
Oh,
while
yeah.
he was in. He was like.
but you gave him mitigating.
Yeah. Because he was responsive and he programmed.
But this,
this
How
is
is-
we
control.
learned in May, this is historical, not now.
Now,
Control
Control
behaviors, historic. Offender changes now.
and Wayne and I both put something about,
See, Pat and I used to be confused by this, but we had it clarified in May and now hammer.
frequent offenses due to substance abuse.
Yeah, no.
You repeated yourself. You gave him credit twice for programming.
I was.
It's okay, Lit, we understand.
They're almost
We
always
just
like
gotta
aggravating in
repeat
that.
itself
But
a
in
lot.
the future, I will see no change.
Touche, Wayne. Oh.
And offender
Totally.
change was, I put neutral and they put mitigating. I put, although he has completed programming and is doing well while incarcerated, he has not had a chance to demonstrate his compliance once in the community because he's incarcerated, and I don't know that.
Yeah, but he'd been out before, hadn't he?
I put a mitigating, you got a mitigating?
I got
I know.
neutral.
Oh, yeah.
You're wrong.
Well, Lynn and I are correct.
You're
Yeah,
wrong.
evidently.
Wrong.
Obviously, you're wrong.
Yeah, I guess I am.
Yeah, this is the DUI guy.
No, neutral is not wrong.
No, the-
No.
I know.
You go in the
That's
opposite.
the opposite way.
Neutral's okay.
Neutrals are fine.
Good.
So weren't too bad, I guess.
I think we're more in sync
Yeah.
than where we talk about
It's
it.
coming
Well,
along.
the ability to control behavior was almost always gonna be aggravating.
Hmm.
Because what they are. I mean,
Exactly.
how could it not be? Couldn't be in jail if they were the control of behavior.
Unless you get
it
a
was a
first time
DUI.
offender.
Yeah,
Right, which
and
is
then is he
rare.
mitigated or is he neutral?
Yeah.
I put him neutral. Because he's committed a crime.
As a whole,
your
how are you
one-
seeing them?
Your one exception to the rule, I would say he is a neutral, not a mitigated in that category.
Like,
Yeah, I would have changed.
I haven't looked at it as close as I
At what
could have,
thing?
but I think,
Thing?
I think,
Oh
I
my
think
God,
we are
sorry.
coming in more in sync, and I think it's just a matter of taking some time to look at, are these outliers? And I think once we can get back on track of looking at these every month, it'll be a little bit.
I really find having the manual
Yeah,
open as I go through these. Mind you. what
I
the-
do.
I do the same thing.
Yes.
I have it all.
I do the same thing.
I hate to bring this up,
Uh-oh.
Then don't.
but didn't you say June was when we were gonna do everybody?
We were looking at July 1st when, originally it was June, then we were looking at July 1st when the new parole summary was being used across the board for DOC.
We want to get Katie and Sam up to speed on it.
I think September 1st is a realistic date, once everybody's all together on every page.
Do an SDMS case for.
For every offender,
Not just three.
not
I mean,
just two.
Honestly, at this point, we are like 2 or 3
Yeah.
days shy of 1 year.
Yeah.
I would almost encourage that it be done for all cases. Or at least up it from 3. There's only a couple hearing days a month where it's gonna be a burden. In my opinion, for the amount of cases.
Yeah.
Some hearing days, I think, correct me if I'm wrong, because you two are doing the schedule. Some hearing days, we don't even hit the quota for 3, I don't
Can I
think.
make a suggestion? Let's continue with the 3 that are identified, up to 3. But that we all do like a paper document or just a notepad completion of all the others. So while you're only introducing 3 into the folder, you're doing them on all of them. Take the time to do.
Are you saying because that's easier because you can handwrite them quicker than you can type them?
Well, that's what I'm doing now anyway. and it
So
works
no,
good.
I'm just saying,
And
what's the
you're typing
difference? Because we could,
The difference is, yeah, I find I take the 3 that I've got to do. I have my paper document, and as I read through the case, I'm filling out the
Yeah.
SDMF form. And I put in notes where I want to ask questions or make sure those issues are covered. And I'm doing it for all of them now, because basically
Mhm.
it's the same information. Then after the hearing, I go back in and fill out the folder one.
so I guess here's my,
So this is a way to sort of transition to all of them.
so here's my question is, if you're doing them by paper, if there's the ability to, you don't necessarily have to go in and type them. You could scan them in. I'm okay with that as long as we have a copy. I'm just saying, I guess
Yeah, but I'm crossing stuff out.
I know.
Let's
I'm
go
just
to
trying.
5.
Yeah, I'm just thinking, if you're gonna advocate for them to do them all by their notebook, why don't we just fill out forms? I don't know. I guess what's the hesitation about going to more
Time,
Time, yeah.
time? Because you don't feel like you're getting, I
I
mean,
spend a good 20 minutes after the hearing doing them.
That does take some time.
yeah, and I mean, I've gone from, wait. I can show you reams of legal pads of how of how I used to do this. And it's really not much different. The way I look at a case and make my notes before I go to a hearing, because I never trusted computers. And a few times it worked, because I could look at my pad and say, oh, his expiration date is, his date of birth is, and these are his. I documented all that since I've been on this board. So, I mean, I've got streamlined, I can go down, boom, 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 and make my notes. I still do that, but now I sit here and try to answer each one of these questions, and I can pretty much answer them from the notes I've made. So it's, when I said last time, it's redundant, it's double redundant, and now with your new beautiful form that is almost online, it's gonna be a whole lot quicker for somebody like me to go, Well, they've asked and answered that question, asked and answered, right there.
Okay, so can I ask the process question? For all of you who are taking your handwritten notes still, why are we still taking our handwritten notes and not taking it on an SDMF sheet?
I was just gonna ask Wayne that.
And I was gonna
I
ask,
thought you weren't supposed to take notes at all.
we're not supposed to be, all notes should be discoverable.
I'm using the sheet.
Yeah, and all these are gonna be discoverable, and all of his X out ones, and every time you make a correction, those are all discoverable.
No, they're not.
Oh, I just heard something different.
So part of the
I'm gonna
record
shred them before.
Until you make it part of the record.
Well,
You complete it.
until it's completed.
It's a record.
So my question is why are we doing the redundancies? Why aren't we just doing the
Because it's
SDMF?
by hand, it's more, I don't know, I'm typing
I got two
this
screens
up.
going now.
I don't get, I would be, I
It's the
was
typing
going,
part.
I have Windows open. However, I'm also old school and I write everything in, but like for question, when I go read the case, I still have a notepad that I keep with myself for the question, like for
Right.
each case, it's okay, what did I see that I want to ask a question on? I don't write everything like you're saying, but I do write an awful lot for each case.
So I'm just thinking for a second, just follow my kind of.
Because it's very hard to type.
No,
While you're in Teams, while you have your second screen, it's the typing.
Just listen for a second. So why either take blank SDMF forms and do them and put your questions on it, or just like, we number the things, like criminal history is 1. And they just put your scores next to it with your questions as you're going through. I'm just kind of
I know.
not necessarily looking at the typing of the form as you're doing it, but restructuring the way you're note taking to make it quicker, so it's just plug and play at the end of the hearing.
I understand what you're saying. I'm just saying that, absolutely, I understand. It's just a habit. I have my notes here and I feel like I have the form up on my screen and I'm filling it in and then I will have like little comments.
I don't think most of the time it's gonna be a problem.
Yeah.
It's just,
I'm just saying, I mean, I understand where you're all going through. You should see the 3 of us debate process, office process. Because I do things crazy different than Colby does, or Carla does, and we all think and act differently.
Just
I like
a
that
habit.
form. Yes, I like using that as a note
Yeah.
taking. It's organized.
It's structured,
Ties
and
right
it
in.
is. I have seen a difference in how the hearings are conducted. You may,
Animated now.
I feel like they're more individual based. They're not always the same questions being asked. You may not feel it, Wayne, but to me, it feels like it just feels different. It
Yeah.
feels more
I agree.
personal.
Well, Tom just takes all my questions now.
Do I? Oh, I just,
I'm trying to alternate between those.
I always alternate.
I know, and I'm never ready. And like, I was gonna have.
I usually do every other one.
The motion thing though is what gets me a lot of the times, is who's given the motion.
Oh, yeah, Tom, I'm like, chicken.
It's same thing with Wayne. Whenever Wayne's on, it's always
The other person.
the other person's giving the motion.
He did it with me when I
Yeah,
was
Lucy was on, I heard the motion, cause I'm like, no, I'm not going to another damn deliberative session.
Always the thing is like, can you work out who's given the motion?
determine it ahead of
And
time.
Tom, you were so cute that day. Both of us were just silent. And then you said, I move for deliberative
I
session.
figured nobody.
And we get in there and he goes, I didn't know what we were doing.
I knew what I was gonna do, I what everybody else was. So,
Oh, no, that was funny.
and that is a issue though. Maybe we should do a thing ahead of time, who should make the motions for that
Yes.
session.
Sure,
That'd
We'll
be
make
good.
sure we do that from now on.
I vote for not doing anything.
I like that.
I vote not it.
Not it.
Okay, Tom.
Got it.
Tom and Wayne.
All right, so we're gonna start working on that.
How many are you guys doing?
5?
Don't look at me.
What are we working on?
Can we go to 5? Do I get 5? That nice.
I'll take care of
Have a
it.
deliberative
Take care
session.
of 90%.
Deliberative session.
4? Each in the middle? 4. 4, done.
Engulfing.
And on the new forms only.
Oh, God.
Yeah,
Write that
no,
down.
no other notes.
Everybody saw this, go look at, everybody's all done, look at Dean's, and go back in and just change it to Dean have to, and we'll be
Yeah.
100%,
Yeah,
we'll be 100%.
Well, I just go in and look at your guys' stuff and just kind of pair it a little bit and put the thing. It all agrees. It all comes out exactly the way it's supposed to be. It's simple. It's really simple. Never have.
Ooh, how did I find the
I
time?
love that. That's true, the time.
Burying everybody's at the form.
Yeah, but you don't have to read a case lid. You just go and look and say,
Look at this, we're 100% for the month.
yeah.
Nobody's laughing at us.
No.
no,
Um,
you're pathetic, we know.
That's a no.
So I guess we're going to 5.
Five.
Should take care of
Four.
90%.
Four.
Oh, was it
Four.
4?
That's what I heard. I'm
I heard all of them.
That was me. All right,
I heard as soon as all the new summary is out, it's all of it,
Oh, boy.
Well,
so.
what if we do this?
Oh, no.
4 on Tuesdays, 5 on Wednesdays.
Whichever ones have the new format, we do those on SDMF. I mean, you gotta look at them anyway to
Okay,
see
can I
which ones
say
they are.
something about the new format? Is there any way to get a little thing in there for the date of the last record
it's in
check?
there. It's in there now. Saw it in the last one we had the other day.
Is it?
Oh, it is?
Record check date.
It should.
Perfect. I'm happy. I didn't see it.
Somebody had put one in.
Yeah,
Yeah.
a couple of them. Even that not on the new form, a couple of them had
Yeah.
baseball scores.
That's okay.
Only because I think we're already taxed in the office enough.
Oh,
That's
But
the
we
only-
don't matter.
That's what I
I
loved
just figured
about
they
the
gotta
old one.
pick out an SDMF.
Right now, you know how they're picking it out?
There's just, yes, random, but Wayne suggested they only do the ones that
Yeah,
on the
but
new
what if there
format.
is none in the new format? Are you gonna just get off and not do any SEO cases nowadays?
See,
That's a
the other
good
one, right, is
suggestion. No, if there's one that,
I really, really want that box back.
what box?
The date of the record check.
It's
I thought it was in there last week.
No.
I saw the old
It's
one.
on the old one, it's not.
It's not in the new one.
The one we had last week was an old one.
Must have been.
Probably.
Yeah,
So like this?
Yeah.
Wait, no.
Yep, that's the one that she's talking about. So
So-
that's the old.
I'm just gonna, so we're moving
That's
to
the old
4 SCMA cases a month. If there is a possibility to get it on the new parole summary, we'll try our best to mark up the new parole summary. If we miss some, please do not shoot the messengers.
We won't,
Copy.
we won't.
Okay,
Does that work for everybody?
that works.
Date box.
See, this is the old one.
Okay.
My schedule, I think it's all we have left.
Okay.
That's the new one.
And Dean, Sam can do
Mhm.
hearings towards the end of the month and she could possibly cover if needed.
Towards the end of the month, you mean like the 23rd on
For
it?
last week, maybe not do every hearing, but
Oh.
just transition her in slowly.
Okay.
I suggested she could take the whole month off possibly.
Yeah.
But she said she'd be willing to come in, transition in slowly.
Okay.
And if we need some last minute coverage, she could possibly cover.
Okay. Anyone else have any dates in July? I got yours, Tom.
Yeah, I am leaving on, I think, the 8th of July. And I think I'm coming back on the 18th.
Ooh,
Amy's taking Sonoma to Ireland. So I get to babysit.
are you doing hearings during that?
Yeah, oh, yes,
Okay.
yeah.
What are your travel dates?
And, the 8th and the 18th.
What's it matter? They never have internet in Florida anyway.
That was one time.
Oh, it's been more than once.
I hope it's,
There's no hearings on the 8th.
huh?
There's no hearings on.
You're right.
You're okay for the 9th?
Yes,
Gonna be traveling back from Michigan on the 9th.
the 9th.
The flooding
Okay.
they have there,
I can do the 9th.
That may be a trip, well,
that may be a
look around.
Wayne?
I'm gonna have some travel days, but I'm not sure when, so maybe I can work around them once you
Okay,
throw this up.
Then I'll forget to update my calendar where Wayne's moved and think. There was
I'm
one
not
last week,
available
and I was-
19 through 25.
Holy Lord.
But everything else. Are we having an overflow day, even though it's
We
that weird end of the month? this
So
month?
I forgot to put staff meeting on the schedule.
Oh,
Now that it's to me, even though I don't do availability. I
well, you
forgot
gotta
to
get Katie first.
put-
I'm still good like usual for all Tuesdays. I could probably do if you need me, I could probably do a Thursday, like maybe the 11th or 25th, but I can't do the 18th because that's Bennington.
Yep.
If you need me on one of those Thursdays.
Okay. I'll just put a question mark there.
But you'll know sooner than later about those Thursdays, right?
Absolutely.
Just so I
Usually
can
I'll try to
rearrange,
get-
just so I can
I'll
rearrange
get it
my
out to you
clients if
before the end
needed.
of the week.
so were you proposing the 30th?
I was gonna propose the 30th for staff meeting. I forgot to put it on the schedule.
I can only do teams.
Are we talking in person again, or?
But it's really up to everybody else because we have a hybrid model.
How do others think?
I'm good. Tuesdays are best for me anyway, so
Person.
I'm good.
I'll be on teams. I'll be in Norway, but I can come on the screen.
Okay,
What time is it in Norway?
3 p.m.
Say afternoon.
at 9. 6 hours difference. So 9 a.m. It'll be
3 p.m.
3
is night.
No, 3 p.m. Well, I mean,
Wow.
even if it was 3 p.m. at night, it'd be light as
Well, you
this
just said it
outside.
was
So
3 p.m. and then you said night.
7 of us.
Is it different in Norway, p.m. and a.m.?
And then the overflow day for July, we were looking at July 31st. I think that's what you put on the calendar,
yeah, I can
just to
do
keep
that
it in
day.
July.
I can do that day.
I can too.
So luckily in June, we didn't need one.
Oh, so I don't have to work this Thursday?
you didn't get the memo 2 weeks ago?
I haven't seen the memo.
I was thinking
Sent
you
it out.
said something.
Oh,
2 weeks
long
ago.
time ago. Yeah, no overflow day.
Huh.
It went out with Northern, yeah.
Yeah, let's go. Well,
You have to send a special one to me.
Excellent.
I like it.
Also, Tuesday, July 16th, I've had a request from prisoners' rights to not schedule any violations that day. So I may be doing some shifting of hearings that week to put the violations on another day. I'm working with the legal teams on Monday to figure that out because they have Dawn's out of state, and Annie and Jill are both in bench trials that day, so they asked if we can. So
Okay.
I'm starting to work more with both legal teams to try to mitigate some of the as they're working together to mitigate some of the postponements, try to find out when we're having the longer hearings. So maybe we can schedule accordingly. So, because we've had 2 hearing days this month go to almost 2 o'clock.
Yep.
So I'm gonna start working a little bit, get myself working a little bit more with the legal teams on some of the violation hearings.
Good.
Without giving any advice or anything, but just planning preparation stuff.
And the staff meeting on the 30th is still at 9, right?
Yes.
Anything else from anybody? Don't forget your expense accounts.
I can't bill for the overflow day, huh?
Go ahead, try.
One of us will catch you.
Are you that hard up, Wayne? I can spot some money there.
Right, what was it? Oh, when we swapped, I told you I had one scheduled, not the other, and I sat down at like Gonna go into Swanton for something. Oh, dark on in the morning. Well, I said, I'm gonna print the calendar out so I know what I gotta look at tonight when I get home. Print out and looking at the data going. Freaking parole hearings in an hour. Oh, shit. Oh, that would have been, I was waiting for Pat to call me and go, where are you? I was gonna say, Route 78, about halfway between Swanton and Iowa.
I would have called you too.
Motion to adjourn.
Second.
All in favor?
Aye.
Good meeting, everybody. Thank you.
Non-negotiable.